Situated thus, in view of the above noted discussions, we reach following irresistible conclusions. A person having qualification of diploma in medical laboratory technology from an institution which is neither recognized by the government of Odisha nor by AICTE cannot said to be possessing the requisite qualification cannot be said to be possessing the requisite qualification for application of Rules 4 and 5, read with Rule 9 of the Rules of 2019. In terms of the Rules of 2019, even in the absence of approval, recognition of AICTE of an institution, a diploma in medical technology granted by such institution can satisfy the requirement of minimum qualification as laid down in column 4 if such institution has recognition by the state government of Odisha. The opinion of learned single judge to the effect that the respondents fulfill the minimum eligibility criteria as laid down in the rules of 2019 for giving them benefit of regularization by applying the provisions of Rule 4 and 5 of the said rules cannot be accepted. The rules of 2019, framed under Article 309 of the Constitution of India, has force of law which bind everyone, including this court, exercising power of judicial review under Article 226 of the Constitution of India, unless they are challenged on limited permissible grounds. The High Power Committee, constituted for the said purpose, had no other option but to follow the provisions prescribed under the rules of 2019, which in no uncertain terms prescribes the minimum educational qualification for such absorption. The direction which has been issued by the learned single judge for regularization of the respondents situated thus is against the law, that is the rules of 2019 framed under Article 309 of the Constitution of India. No direction or any writ in the nature of mandamus can be issued in disobedience of law in our considered opinion. Power of relaxation is a matter which can be exercised by the competent authority under Rule 10, which is necessary when it is necessary or expedient to do so in public interest. This court exercising power of judicial review should ordinarily not issue such direction as to relax the eligibility criteria, which is primarily within the domain of the competent authority, though the court may direct consideration for such relaxation. We are not restraining the appellants from exercising the power of relaxation available under Rule 20 of the rules of 2019. In the matter of regularization of these respondents, we, however, observe that if any such decision is taken, it shall be incumbent upon the concerned authority to record satisfaction about the genuineness of the institutions where the respondents claim to have pursued their course of DMLT, and such relaxation would not in breach of any other law in force. Reliance placed on behalf of the respondents on various Supreme Court's decision on the point of regularization in service have no application in the present set of facts governed by statutory rules framed under Article 309 of the Constitution of India. We do not agree with the view taken by the learned single judge that since on the date of appointment of the respondents on contractual basis, there was no prescription that they must have acquired the requisite qualification from an institution recognized, approved by AICTE, a right accrued in their favor after completion of 6 years of service for regularization. Recruitment, absorption, service condition of employees in a service under the state is governed by the service rules. In the present case, rules of 2019 have been framed in exercise of power conferred by the proviso to Article 309 of the Constitution, in supersession of all the orders, instructions issued in this regard, a person's claim for appointment or regularization shall be governed strictly in terms of the provisions of the said rules till they are declared invalid. The reasoning assigned by the learned single judge that the case of the present respondents stand on the same footing as that of the persons whose services were regularized by the orders passed by OAT as noted above cannot be accepted, since such orders were passed prior to coming into force of the rules of 2019, and the cases of the respondents were to be considered under the said rules. For the reasons above mentioned, in our opinion, the impugned judgment and order passed by the learned single judge deserves interference, as the same cannot be sustained. Accordingly, the impugned judgment is set aside. The appeal is allowed. Writ petition 3301 of 2020 stands dismissed. We'll put our signatures.
Appear Vice Chancellor OUT online. Then now BC is present.
Why didn't you implement the High Court order?
We are extremely sorry, my lord.
Was there any order of stay?
It was not there.
So
Therefore,
did you have the authority to stay the order of the High Court?
Sir, it was due to some miscommunication that since an appeal was pending, perhaps that led us to keep it on hold. But I tender my unconditional apology for that.
How much time will you take to pay the salary?
15 days, sir.
15
kindly
days.
granted.
Why 15 days?
Sir, they are in a scheme funded by Government of India, and we solely take the responsibility of mobilizing and dispersing.
What is your name?
Prabhat Kumar Raul.
Mr. Prabhat Kumar Raul, the Vice Chancellor, OUAT, Odisha University of Agriculture and Technology, has joined the proceedings online. First off, he has tendered unqualified apology for not honoring this court's order passed in WPC number
21192.
21192 of
2023.
23. First off, he has submitted that he shall ensure that the petitioner is paid the salary for the period during which
4/7/2023 to adjournment.
just a minute, during which he or she
She.
was not allowed to join to join despite an order of this court. So stop. Let's this matter on 3 weeks. We are giving you 3 weeks. Please
Sir.
ensure.
So kind of it.
This is the matter. Personal attendance of the appearance of the Vice Chancellor stands dispensed with, subject to the condition that the amount of salary which the respondent is entitled to is paid to her. If it is not paid, then you please join. If it's paid, then yes.
Let that respondent number 1.
Respond number 1.
Item number 2.
Statement, please.
Item number 2.
we had approached the Honorable Supreme Court challenging the order of this Honorable Court where direction was given to regulate the service of the petitioners or petitioner who has a NMR. So now the SLP has been dismissed. We are taking steps for regulation and payment of compliance with lordship's order. So I pray 4 weeks time may be granted so that you can do it for us.
It is stated on behalf of the contemners that against the order violation of which has been alleged in the present contempt application, the state had preferred an SLP.
Yes, sir.
Which has been dismissed recently.
Number is 12/2/2024.
On
12/2/2024.
recently. Stop. He submits that the steps are being taken for implementation of this court's order. Stop. What time?
4 weeks time, Lordship.
He seeks 4 weeks adjournment to inform this court about full compliance of this court's order. Does this matter on 4 weeks?
Yes.
Item number 3.
High Court committee meeting. Yesterday it was there.
Yesterday, the matter was there. I have received the written instructions from the department. They are going to hold the high power committee meeting on 12/7/2024.
No.
And the case
That
of the
they cannot do.
because the members of the high power committee are from the vice chancellor of different universities
Of
different universities.
from the outside the country.
No, my lord, from
Then?
the state
State.
universities, and it will be headed by the secretary of the department. So all of them have to be intimated and communicated
So
beforehand.
what, date fixed, date has been fixed.
The date has been fixed to 12/7/2024.
It has been stated on behalf of the state of Odisha.
My lord.
State of Odisha that high power committee meeting is scheduled to be held on 12/7/2024.
May I furnish the instructions to my lords?
If it is not privileged, yes, you can. Yes.
The last paragraph, the lordship will look at. The last paragraph. As such, the inconvenience occurred in addressing the proposal of the petitioner is sincerely regretted. It is hereby submitted that the same will be placed and taken up in the
Understood.
next high power committee meeting to be held on 12/7/2024. In the last paragraph, they have stated.
For consideration of grant of approval to the petitioner institution, petitioner-institution. Stop. This matter on 15/7/2024.
Item number 4.
The Insolvency and Bankruptcy Code, there's a provision of appeal under section 61. Now, the impugned order is that of NCLT, wherein which can be taken in appeal before the NCLAT. So, in this case, also we have made that disclosure that we have preferred an appeal. My lord knows that under section 61 of the IBC, the period is 30 plus 15. Beyond that period, it may not be condonable. So there was some confusion. Now we have advised them that they'll raise all these grounds in appeal. In paragraph 18 at page 16, we have also mentioned the appeal number in this writ petition. So this writ can be disposed of, granting us liberty to raise all this in the appeal before NCLAT.
Paragraph.
Paragraph 18 at page 16. The appellate provision is at section 61 of the IBC, which has that 30 plus 15.
Mr. Gautam Mishra and senior counsel appearing on behalf of the petitioner has submitted that the petitioner has preferred an appeal before the NCLAT Delhi selling the same order dated 28/2/2024, which is under challenge in the present writ petition. To stop, he seeks to withdraw the writ petition with a liberty to pursue the said appeal. Stop. This writ application is accordingly dismissed as withdrawn with the liberty as sought.
Item number 5.
I pray for after launch on behalf of Mr. Bhavan Shankar Raigal.
Pray for
After launch.
after lunch. You cannot decide our timing. After lunch, you will do after in the morning. You can adjourn the matter, but
Let it any other day.
item number 5.
Yes, Lordship.
Tomorrow I may forget the facts. But have you filed counter affidavit?
Not it.
File. That requires consideration.
My lord, was on the question of maintainability of the writ.
What?
My lord, in fact, they have challenged the induction of certain teachers, those who have acquired the qualification after the cut-off date, into the gradation list. That is under challenge. But
You take the plea, that plea in your counter affidavit. In fact, what I have been able to understand is that the persons who have B.Ed qualification
yes,
are discriminated against such persons who do not have. Some averment is there that persons having B.Ed qualifications suppress their qualification
yes.
to get the advantage. So this is an anomalous situation.
But those identified group of teachers have not been implemented as parties.
We will see that aspect,
Yes, my lord.
whether they are required to be treated. If we have to lay down a law,
My lord.
we will see, or we can see while filing counter affidavit. You may decide to review your own decision
Will file.
or take corrective steps. We don't know. If you notice, so and so accepts notice. Mr. Saswat Das accepts notice on behalf of the opposite parties. So, as requested by him, 6 weeks time is allowed to seek instructions and file counter affidavit.
Item number 6.
Matter relating to renewal of NOC. The matter was on 18th May. The NOC was granted me on 16 January 2024. But the last date for grant of submission of for renewal.
What can we do?
In WPC number 14/127/2024 on 18th this month, June, your lordship may the similar matter.
Similar, you can
Dispose of
all right.
WPC number 141/27/2024. That matter is similar. That is very same order may be passed in. The matter was on list on 18th June.
I know my name may be given for DMT. Arsimanti for DMT.
Yes.
As in 14127. Item number 7. Item 7.
There is no representation on behalf of the petitioner despite repeated calls. Monday. Is this matter on Monday? Yeah. What is this matter about?
My lord, this is regarding that notification which has been challenged under 168A, 9 of 2023. All the matters have been fixed for hearing on July, 2nd of July.
So we can fix this also.
Lordship, as your lordship desires.
Copy have to be served, so that it is.
Copy to this all on the GST council.
Yes, madam. So we are.
My lord, the lead matter is WPC number 3703 of 2024.
It has been stated at the bar that batch of writ applications involving writ applications, WPC number 3703 of 2024 being the deed case, involving identical issues as involved in the present writ application, have been directed to be listed on
2nd July.
2/7/2024. So stop. Let's just repeat the petition on 2/7 along with 3703 2024 and back.
Copies.
Copies you have served?
Yes,
Copy of
yes. Additional order copy also I have served. No, a similar order copy also served. Similar order copy.
No.
There's a
the
written order.
writ petition.
Petition copy also served.
For listener, accepts notice.
We have also sought to Union of India,
Yes.
number 1 also.
So all of opposite parties have served copies. Till then, let's say. Till then, let's say I may be put.
Yes, same. What's it?
234.
2, 3, 4.
I am for opinion number 1. Union of India. 1. 8.5. I'm 234.
I am for 4 and 5. I am for 4 and 5.
Four and five. Similar applications, writ petitions must be pending throughout the country. All the
My lord, Kerala and Patna, they have found that this notification is intravirus, not ultravirus.
In department's favor, let's say.
In favor of the department.
when
But-
that judgment
Last month only.
last
One.
month. All
But
right.
in all other high courts, it's
Chief
pending.
Justice's Honorable Chief Justice's bench.
My lord.
In all other high courts, it is pending in that. Kerala and?
Kerala and
Kerala and
Patna.
Patna. Yes.
Item number 8.
Please, your lordship. And this matter, your lordship, on 25/2022 at page 43, your lordship has directed for the refund of excess royalty that has been debited from the arrears of the petitioner.
Which item?
Item 8, your lordship. And at page 43, your lordship, annexure 4.
What is the decision in Akul Charan?
In that, your lordship, it was decided that in case the royalties have been excessively debited from the RA bills of the contractor, then the same has to be reimbursed back to the contractor. And basing on that, your lordship on 25th of May 2022 has passed the said order. And thereafter, the department has calculated under page 45, if your lordship may see. First paragraph, last two line. The excess royalty reimbursement amount of royalty deducted at enhanced rate is computed.
No, you are reading page 45.
45, your lordship.
Second paragraph.
First paragraph, second line.
First paragraph.
The last line.
Last line, the excess.
Yes. Excess eligible reimbursement amount of royalty deducted at the enhanced rate is computed to rupees 40,592 for the above work. And on the next page, your lordship, at page 46, the Tahsildar Dharamgarh was directed to refund the said amount to the petitioner. However, your lordship, it has been around 2 years. We have been following up with them, but there has been no action from the Tahsildar Dharamgarh.
Yes.
So lordship may give me a week's time, your lordship, I'll seek.
A day's time. Monday.
Monday, your lordship.
You do it, otherwise we'll impose cost. Because this writ petition was not at all required to be filed.
So lordship.
And this has been filed. So you can tell the officer.
By Monday, your lordship.
Monday, as requested on behalf of the estates. Let this matter on Monday for her to inform as to whether the amount excess royalty amount as determined by
OP number 2.
OP number 2 has been refunded to the petitioner or not. And if not, you may inform them that we will pass a judicial order for initiation of disciplinary action against the officials. This is simple 40,592. And this person is approaching this court to implement an order passed by the executive engineers. This is too much.
Item number 9.
Of less lordship.
You asked the Tahsildar also, because on page 46, the Tahsildar has been asked to dispose of also.
Yes, your lordship.
You get instruction from whoever is responsible.
Yes.
May I please, Madam? This is an intra-court appeal challenging the order of the Honorable Single Judge passed in a contempt petition, wherein the original order has been modified by the Honorable Single Judge, which is beyond jurisdiction, my lord. My lord, your lordship may kindly see the order under Annexure 1.
Mr. Das, the order has been modified, or the single judge held that no contempt is made out?
Yes, my lord, your lordship may kindly say, and the Honorable Single Judge has opined that.
Why do you say modified? How do you say modified?
Your lordship may kindly see the order last paragraph 9.
Yeah, this is
Contempt appeal. So the contempt has been dropped.
Yes.
Dropped.
No appeal lies. No appeal lies against an order whereby the contempt proceeding is dropped.
My lord, what is the fate of the? I put a question
Even
to myself.
you see, there are two things.
My lord,
punishment.
I do not want to any punishment.
Then,
my lord, to implement the order of the.
If you don't want punishment, then contempt does not apply. Contempt of Courts Act.
My lord, the original order will go. Original order in the writ petition will go.
Then you challenge before the Supreme Court. And we are not sitting in an advisory jurisdiction. We cannot advise you what to do, what not to do.
My lord, your lordship may kindly see the order, the opinion of the Honorable Single Judge, paragraph 9.
See, there was an order.
My lord.
You alleged disobedience.
My lord.
learned single judge reached a conclusion that no contempt is made out. Against that, writ appeal will not lie.
In a contempt jurisdiction, my lord, the honorable single judge has no competency to alter the order of the original order, my lord, in the past in the writ petition, my lord.
Suppose if this bench passes an order,
My lord,
which according to you is illegal, then what will you do? Can you file a writ appeal? You will have to go before appropriate court, forum.
my lord.
But Mr. Das, what is the original order?
Original order I have quoted in my.
Yes. OP number 2 will cause registration and OP 5 will act accordingly.
No, my lord, the prayer is allowed, paragraph 4.
Paragraph, yes, paragraph 4.
Prayer is allowed.
What is the direction?
My prayer was.
What is the direction?
Direction, the opposite party number 2 will cause the registration and opposite party number 5 will act accordingly, my lord. My lord, my prayer was to register my lease cum sale deed. That has been, I have mentioned in paragraph 2, my lord. My prayer.
Look at paragraph 1. Prayer is that to register the conveyance. That is all.
Yes, my lord. My lord, my prayer was to register the lease cum sale deed, which was advertised by the Odisha State Housing Board, my lord. Accordingly, I applied.
So, counsel, there was no the learned single judge has hailed that there was no specific direction to execute and register lease cum sale deed in favor of the petitioner.
Yes, my lord. Now, the honorable single judge in a contempt jurisdiction has opined to register the lease deed.
Even
that is the only my humble submission before your lordship.
There is no direction. They said that they are willing to register the lease deed.
Lease cum sale deed, my lord. My prayer was lease cum sale deed.
Maybe.
Right.
And according to the advertisement made by the Odisha State Housing Board, my lord.
All right.
Present appeal is said to have been filed under Section 19 of the Contempt of Courts Act, putting to challenge an order dated 23/4/2024 passed by learned single judge of this court in CONTC number 7096 of 2021, whereby he has dropped the contempt proceeding with following observations :8 and 9. Full stop. Learned counsel for the petitioner has submitted that in effect, while dismissing the contempt application, while dropping the contempt proceeding, learned single judge has altered the original order which was passed in WPC number 31638 of 2021. Stop. Next, we are of the considered view that the learned single judge has not exercised the power to punish the contender by passing the said order. Rather, the single judge has dropped the contempt proceeding. So stop. In such view of the matter, an appeal would not lie under section 19 of the Contempt of Courts Act. Stop. This appeal is accordingly dismissed.
Item 10.
That's in item number 10. I have just received the instruction from the department. Now, after the writ appeal was allowed, the law department has already given, law department, also GA department has given approval to comply with your lordship's order. Now it's pending with the finance department, and within a few days they will give that instruction so that the order can be complied fully,
So is there any law that the orders passed by the court are
No,
approved
it's
by
because it's a service
Your
condition. So
Honor.
it's only approval of the
Desk
financial
officer?
approval, not concurrence is not there. Only approval, interdepartmental approval.
They took 3 times, my lord. On 3 occasions, my lord senior took time, my lord, to implement the order.
So what do you want?
As your lordship, my lord. As your lordship direct, my lord.
You want as your lordship direct?
I want to for my appointment, since person junior in the merit list.
All right. How much time?
No, only 15 days. They got specifically the law and
By way of last indulgence, the matter is adjourned to 3 weeks. So as to enable the contenders to ensure that this court's order violation of which has been alleged in the present contempt application is fully complied with. Stop. We are prima facie satisfied that the contenders have violated the court's order. Stop. The said violation is willful or not will also depend upon their subsequent conduct, which we shall look into on the next.
Item 11.
Date may kindly please.
Date has been given.
11 and 12 lawsuits. Order has been complied with.
Complied. And counsel for the states. There are 2 contempt applications. Complied with. There is no representation on behalf of the petitioner. It states that it seems that the petitioner has lost one petitioner or more than petitioner has lost interest in the present matter because the order has been complied. The compliance affidavit has been. In one second case, compliance affidavit has been filed.
No, affidavit has not been filed. I've got the
Not filed.
orders from the.
All right.
Item 12.
12 also order has been complied with. I'm giving a copy of the extract of the order passed by the Tahsildar Loisinger to my friend.
Complied with.
Item 13.
2 p.m.
At 2 p.m.
It is 2. Item 14.
The order which has not been complied is at page 11 and 12. And the main case of Narottam Rath, that they have gone before the Honorable Supreme Court, and SLP against that is pending. No interim orders have been passed, but SLP is sub judice. And so far as this case, I think they have not, there's no appeal.
No specific, particular case, no appeal has been preferred. But some main case on the basis of which this order has been passed, that is pending before the Supreme Court. And
You will have
Narottam
to prefer appeal against this order also.
No, this order we have to comply because we have not gone to the Honorable Supreme Court. It is complied. I will obtain instruction because your lordship also granted us liberty to proceed under section 3B if not required. So not that the doors are closed. So lordship grant me 2 weeks time. In the meantime, I will obtain instruction regarding complaint. The ASO was directed to record the lord's name in their favor, only. 2 weeks time, lordship grant. I will in the meantime. I will
2 weeks time. Any question? Discuss background. So it's to seek instructions. As regards compliance of this course.
Item number 15.
May I please, your lordship? Item 15, this is second content petition, Miller. The earlier content petition order is at page 14. 14.
Where is the writ?
No, sir. It is similar. It is the similar matter. Yesterday, one of the matters was before lordship, wherein the direction was to review was allowed. Direction was given to file and representation, fresh representation. Here the same case, if you also kindly come to the receipt they have given, page 15. But there is no mention regarding representation.
This is 4496.
Yes, sir.
Yes, Lord.
Item
There is
15.
no page 15.
Page 11, that is 11 only.
No, sir.
Contempt petition, no annexures.
They've given me a copy where the
What?
Here is the annex.
Yes, sir.
page 14 is the first contempt order, but they have not annexed the original representation.
Let us see your affidavit, your printing.
4496.
Your brief.
Here is the annexure is there, your lordship can point to withdrawal. I'll point to withdrawal.
Annexure is this.
Here is annexure, but your lordship can kindly permit to withdraw. I'll better.
There is no index.
Let us see.
Index is, oh, no.
It is not there in the detail.
There is the index, he has not given the annexures. Sam's reporting has missed that. Achhi annexure. Dekhan.
Where is the writ order?
Reader in fast contempt.
Review, nothing.
That is-
Withdraw. And counsel for the petitioner seeks permission to withdraw this application. This application is accordingly dismissed as withdrawn.
No, there are some orders, it has not been scanned.
Oh, no.
Contempt. First. The order has been put and
Withdraw.
Item number 16.
Item number 16 is connected to a writ petition, now listed with your lordships at item number 45. It arises of the same. The writ application is still pending. The lordships we had admitted that the amount shall be refunded to the present petitioner because she was not allowed to operate the lease. And there, in fact, obtained instruction, the Tahsildar had also appeared. We requested him to get the lease deed which was registered in his favor to get it cancelled, so that the amount can be refunded to him because the government wanted that the lease should be cancelled. The Tahsildar requested, but the petitioner says that she is not willing to.
Let me clarify the position.
No,
one second. Let me clarify the position, man. 2021, they executed lease in my favor. State is the executed the lease. Now, thereafter, immediately they say, issued a letter to me that don't operate this item because there is objection. I have not been allowed to operate for a single day. Now, Sairat was not operated. I approached the Honorable Court challenging that letter. A PIL was filed against that auction. In the PIL, this Honorable Court directed to hold a joint verification whether that Sairat is feasible or not. Joint verification report came. Report suggested that it is not safe to operate this Sairat. So accordingly, this Honorable Court said that the lease cannot be operated. refund the money. Your Lordship passed a specific order on 23/20/24 in presence of my learned friend and the Tahsildar to refund order, impose a cost of rupees 20,000 for their inaction. That cost has not been paid till date. And after your Lordship passed order to refund, to avoid compliance, they went on issuing me letter that you cancel the lease deed. Look, I can't cancel it. You are the executant. State is the executant. So putting the cart before the horse, trying to avoid compliance of my lord's order. Lord, they are saying that now you cancel. It's inconsequential. You yourself have stopped me from operating. What is the question of cancelling the lease deed? You should now refund me back my money, whatever you have collected at the time of.
Is there any communication that you should cancel the lease deed?
Yes, they issued me a letter that you cancel the lease deed. I drafted a draft of cancellation, submitted to them. Please execute it because you are the executant. I also booked a slot for them. They did not appear. I also booked a slot. I have been running after them since 21. It's
So where is that request
that
by
here,
them to you to cancel the?
Yes, sir. Kindly see, that is page 23.
19, 21, 23, I think.
Page 23, the
In fact,
letter.
I'm going to learn a new law altogether.
Yes, sir.
Yes. Where is that communication?
That is page 23, my lord, of my contempt application. They're only that trying to create a bottleneck in the garb of cancellation of the lease deed. That's not at all necessary.
Just a minute, just a minute.
Right. Sir.
Earlier two letters was you cancel the lease deed. Then
How
whenever state you produce the cancelled deed.
Kindly consider, kindly appreciate, my lord. You are the executant. I will produce the cancellation deed. Tahsildar appeared twice, undertook to refund me back here before my lords.
Appeared in the contempt and the writ.
In the writ petition.
Writ petition.
And where is the provision for cancellation?
But cancellation of the lease. But cancellation, I don't think under the minor mineral rules,
There must be provision.
In the notice it must be there.
Yes.
In the rules, there must be provision for cancellation.
Yes, but I'll just point it out. But
therefore, that power is being vested in you.
Yes, I'm grateful, Vinod. And moving a step ahead, if you see page 25, I have written a letter with a draft deed. Kindly see, man. I have been running after them.
In fact, here what has happened, the Tahsildar wrote to the authorities to refund that amount and paid 20,000 cost which was imposed by lordship in his presence. The authorities wrote him that you get a deed of cancellation because till the lease in Bhog, once the amount is paid, if the lease is not cancelled, they may face some consequences. That's why they requested the Tahsildar to get the lease cancelled so that the amount can be paid. That is the.
So on what ground the lease should be cancelled?
Because he will not be operating and the amount which was deposited and lease was agreed.
He was not allowed to operate, therefore refund the amount. That is the only thing.
Yes.
Lease deed is there.
They asked the Tahsildar to cancel, he should have cancelled. Why is he asking him to cancel?
Or that also. In fact, these are non-consequential, but you'll also
please train them. Otherwise, this will amount to vesting the power of cancellation of a lease deed in the
favor of the
lessee. Wonderful. And even without cancellation, the amount should have been paid.
Like once the amount is paid back, she cannot claim that I will be operating. So,
the proper letter.
So who is the officer who asked the Tahsildar to get the lease deed cancelled for the purpose of refund?
He says that the one letter he received from the additional secretary.
So was there any condition put in the order passed by this court?
No. Your lordship simply said refund the amount. As it was not refunded, your lordship were pleased to impose 20,000 cost also. Because there was delay in refunding him the amount, my lords.
List this matter on 1 week. So as to enable an AGA to seek instructions as to whether the amount directed to be refunded to the petitioner and petitioner with cost has been paid to him or not. It is clear from the order violation of which has been alleged in the present contempt application that the contemners were directed in no uncertain terms to refund the amount of
amount Lordship has
deposited by the present petitioner.
amount which I am entitled to.
deposited by the petitioner for grant of mining lease. 1 week.
Lordship, this may be also not item 45. Not that is same matter. My friend has filed a contempt.
But this may be tagged with that.
Yes.
With that.
Date along with WPC number.
Correct. So great.
Item 17.
Contempt adjournment, non-compliance of order dated 4/8/2023, my lord, page 11. There is a direction to settle the land and record the land in the name of the petitioner.
Same matter. The other matter. Our lordships directed the other matter. That is item number 14. Same matter. Lordship, 2 weeks time may be granted so that I can obtain regarding Narottam Ratha. Narottam Ratha judgment. There was a direction to record the land in their favor. Even though we have gone to the Supreme Court, this particular order has not been challenged. So 2 weeks time, Lordship grant, I will obtain instruction regarding
14.
Yes. Item 14, Mr. Isra was doing same matter.
Same date. No, sir.
Yes, same day. Right.
Give it to-
4th July. 4th. And what is the stage of that? Why? See, if there are separate orders, then you will have to file.
Till date, I don't have any instruction whether the SLP has been preferred against all these cases. Because Narottam Ratha, which is the leading case, that is pending before the Honorable Supreme Court. Only notice has been issued, no order of stay has been granted by the Honorable Supreme Court. And the subsequent orders which have
Suppose
been
that
passed,
order is set aside, then what will happen?
Delay of 500 days, 600 days.
maybe settlement will be there because it is not under challenge, not so will be nowhere. We cannot review that order also.
And in some cases, settlement has already been made. In some cases, recorded land has been recorded in the name of the purchasers also. And in our case, they have called us and also taken all the documents.
How many cases have been disposed of?
Maybe
around 500.
more, 500 more than that.
Do that.
Those lease cases are also Westland lease cases.
Oh.
And subsequently, the leaseholders, they have transferred the lands in favor of different persons. And they have got now come to the Honorable Court saying that get those lands recorded in our favor.
By the time you cancelled, it had already been transferred. You've not heard those
Yes,
persons.
no notice was given. Though lease have been transferred, cancelled. They said that notice was not given to the purchasers. They came before Lordship. So Lordship remanded the matter.
So some
Sharing that. Sharing that order. Order of remand.
No,
Supreme Court, what have you challenged in the Supreme
no,
Court?
or not remand me. The Honorable Supreme Court, which is under challenge, there was a positive direction by this Honorable Court to record those lands.
And in these cases?
That is also.
These cases, same order, following Narottam Ratha's case.
Oh, other cases you are saying they were remanded to hear the parties.
No.
Yes, Mr. Mahanti, Narottam is what?
Narottam Ratha is a different case where the Honorable Court has held that the ASO has no jurisdiction to change the record. ASO. Once the record has been prepared in favor of somebody, Assistant Settlement Officer, on the basis of an executive instruction, that is the allegation, that was the allegation, change the records. That was challenged. And that the Honorable Court has set aside. They say, If you want to change the record, then you can initiate 5 by proceeding to cancel the original lease. ASO has no jurisdiction.
The other cases were under 5A.
5, yes.
And this is also under five.
Yes. Yes. So that is challenged before the Honorable High Court, and that was
Not only that, my lord, there are separate aspects has been dealt by this honorable court also.
there are other points.
Other
but the
points
main
are not
issue
in
is
that
that.
judgment. Lease has been cancelled without hearing the purchasers, and lease has been cancelled without jurisdiction that has been held by this.
That jurisdiction
What
part
is, there are two types of cases. In some, ASO has done it.
Yes.
In some, under 5A, but without notice also.
Yes.
And this is also not under 5 MLs. During
Yes, sir.
settlement proceeding, matters came before the assistant settlement officer. Assistant settlement officer refused to record the name because saying that in view of the OJC, the order was passed in OJC regarding this manipulation of records by the erstwhile officers. That is why he refused to record the name. That is why they came that ASO has no power to refuse.
These are all valuable lands in Bhubaneswar. And at
sale
one
is
point of
That is the
time,
material.
no, at one point of time, it was discovered that some manipulations have been made. So that by order of the Honorable Court, it was sent to the Crime Branch Department for investigation. And in the meanwhile, the ASO has cancelled all the records. That was challenged before the Honorable in 2014. And the matter is now to be finally decided by the Honorable Apex Court.
No, but that matter may be decided in case of Narottam.
Yes.
But what about other cases?
Suppose it is allowed, what will happen to these cases? Suppose it is allowed, these orders are there,
Suppose the Supreme Court allowed the state appeal.
then you will file over there.
No.
Then
This order of the settlement officer will stand
in Narottam.
in Narottam.
And
This is not Narottam.
This is a separate order.
All the 500 cases are following Narottam Ratha.
Sir, please tell us that there are 500 orders passed by this court.
Yes.
Based on Narottam.
Yes, madam.
Now, if Narottam is decided in favor of state, then what will happen?
Then the correction of record of right will stand conform.
In case of Narottam.
No, all are similar cases. The subsequent orders are
similar, but the order of the High Court stands.
All the orders shall stand cost.
No, we have to individually file. Yes, your lordship, and individually we have to
But
challenge.
you have not filed.
No, I think more than hundreds we have filed. So we can get
You may have to file 1,000 more. You don't know.
In each and every case we have to file. But all other cases are only that following the judgment of Narottam case, the matter.
Still, you will have to do that.
But each and every case has, that was a high level meeting on this, and this was decided that each and every order will be challenged.
All right, do whatever you want to do.
Yes.
If you don't do, then you will have to follow.
Each and every order.
See, it is very.
One thing more, Milords. In fact, initially, following Narottam Ratha's judgment, Milords, this Honorable Court granted positive direction, you record the land. Subsequently, Milords, this Honorable Court, when we pointed out, your Lordships were pleased to direct to consider the case of the petitioner in light of Narottam case, and if he is entitled, then grant that benefit.
So then you reject.
No, those are separate cases that we are examining whether applicable or not. But here there is a positive direction.
You take policy decisions, but we decide cases.
Right, not
individual cases.
Yes.
So we shall consider
case individual. No, that is true.
Therefore, if appeals have not been filed, they are to be filed. Don't know, will you
A particular case is
as requested.
This
matter on 4 weeks. In the meanwhile, you do whatever you want to.
Yes,
do.
Please.
14.
No, you say a similar matter, you have pushed after 2 weeks.
No, both 4 weeks.
In all cases, also 4 weeks.
In all cases, Narottam.
Item 14, 16 and 17. 14, 16 and 18.
18.
So far, item, my lord, so far item 18 is concerned, my lord. I am VC at Puri, my lord. Please make a glance your lordship's order, my lord. Dated 11th, 21st 11th 2023. Please make a glance. Annexure 1, running page 8, my lord. Please make a glance. In that order, your lordship was granted only 4 months to concern ASO.
Narottam will come later after 4 weeks.
Item 19.
Order dated 6/10/2023 under Annexure 1. That is for non-compliance. That is the subject matter of the present proceeding, my lord. Here, what happened, my lord? The earlier, the petitioner seized the mortgager in respect of the land, in respect of the loan availed by her son. She had mortgaged her residential building, my lord. She approached this honorable court. This honorable court, your lordship may come to page 9, para 3. Directed that you approach the bank within 3 weeks and they will consider. That was the direction. Thereafter, pursuant to that, by Annexure 2, she submitted application along with, as per the advice of the bank, he also deposited 1 lakh rupees within the stipulated time. And then subsequently they agreed, though verbally, as per discussion, that we will settle the amount under OTS and he deposit 2.2 lakhs. I also deposited. I have also given the check.
Contempt?
Pardon, madam?
Where is the contempt?
My lord, they have not passed any order. Now they have gone for auction sale. Auction sale is subject matter of challenge in another proceeding. That I am conscious, my lord. But so far, order of this honorable court is concerned that you dispose of the application accordingly. They have not passed any order. My learned friend is appearing. Let him take instruction what happened to my...
Copy has been served. I will take instruction this matter. Some time may be allowed. Whether it is repugnation has been disposed of or not. Pursuant to the order as submitted, if it has been conciliation made and decided for OTS.
This was passed in 2023. You may pass it after in the October 2024.
But thereafter also, my lord, by Annexure 1, 2, I submitted application.
So no date, no time limit was given.
No time limit.
No time limit was there. It was immediately thereafter I filed. They agreed for the amount.
That we don't know.
That is
they agreed, they did not agree. What did they do? What did they discuss?
But my limited grievance is that, my lord. Now they have gone for auction sale.
Different.
They have not passed any order.
We are in contempt jurisdiction.
But they have not passed any order so far my application is concerned. So that was the direction of this honorable court.
No contempt. The petitioner.
Though time limit was not fixed, but
therefore, when contempt will arise after 1 year.
No, my lord. Now they have gone for auction of that very property.
Was there any direction that before disposal of your representation, they cannot proceed further?
So many months have passed. Let them. My blood friend said that he will take instruction.
Sorry.
And not press. Not press, my lord. I will. So far, the auction is concerned. That is subject matter of challenge in different cases.
Argument submits that he does not intend to press the present contempt application. This contempt application stands disposed of accordingly.
I am for the opposite party.
Item number 20.
Yeah, please. The order that has not complied in Annexure 1, my lords, page 9.
Page 9.
9. 10 is the order.
When was the order passed?
2008.
So you wait for some more time.
No, my lords, they filed review.
Yes.
And review has been dismissed only on, your lordship, at page 13, on 13/12/2023.
So at least till 13/3/12/23, there was no contempt.
I understand that the doctrine of merger will not apply once.
No, doctrine of merger will not apply. You are right. But so far as disobedience is concerned, they were pursuing a review application.
if they are pursuing a review application, then dismissal gives me a cause of action for contempt. I've given a
Well, you are
representation.
right. You are right. So till December 2023, there was no contempt.
No,
After
We had
that,
not-
you are right that after you rightly filed this contempt application, that despite dismissal of review application, the order has not been complied with.
Yes, ma'am. I gave a
Okay.
representation on 26/12, and even after enclosing the order and all the documents, till then it has not been. Only lease deed to be. I've deposited the amount, everything. Only lease deed has to be executed.
Yes.
So that original order was passed on the first day, right?
Original order was passed on.
The first day.
Since the second is the
No.
first day. Yes.
First day.
The first day and hearing the learned government council. And it was, money was deposited for the plot, a plot was allotted, and a lease deed was not executed. And only direction was that
20 years.
deposited the entire amount, so execute the sale deed. Neither they have refunded the amount, they sat over the matter.
Review order is page 13.
Yes, ma'am. On 13/12/23, review has been dismissed.
Yes, seek instructions.
Yes, in fact, I am aware, Milords. Here, against this order of review, Milords, an application, IF to recall this order has already been filed. Because, Milords, here I was the conducting counsel. If your Lordship sees, I filed that affidavit saying that, Milords, when the matter was called, Milords, in fact, due to some miscommunication, neither the petitioner nor the state council was present there, Milords. So this
You
all.
are the petitioner.
Just.
Because I know that neither the petitioner nor the counsel for the order said both were not present, because there is also another case tagged to this. Both cases, nobody was present, so this all court were pleased to pass this order. There, I filed my affidavit saying that review, this is not the, it was never placed on merit because I was absent, nobody on behalf of the state appeared. So please recall this order, hear this on merit. That IA is still pending, and we have taken steps to get that order. Get that matter listed, Milord.
IA in which case?
In this review application, Milord.
IA in review?
Yes, Milord. Because the review, when the review was taken up, Milord, better was called. The state council, I was the state council, Milord. I was absent in that, Milord, at that time of call, Milord, because I was
so that out review of in the disposed of review application, you have filed IA.
Milord.
Review of review.
No, not review, to recall that order because it was not placed before this honorable court, because there is on record that we have got some substantial.
Where is that order passed in review?
13.
That is page 13. Page 13.
So, IA will not do.
So only April, lost may call it 2 weeks after. In the meantime,
Yes. What do you have to say? He was not there, he says.
Let that IA be disposed of, then after I'll. Let it be pending,
Learned counsel for the AG.
because I have not been served a copy. So.
Representative, please give him.
Yes, I will give you.
Learned AG appearing on behalf of the contemners has submitted that an interlocutory application has been filed in the disposed of RVPET number 207 of 2008, which is pending. Most often is this matter on 8 weeks.
Orders item 21.
There is a delay of 142 days. The Honorable Court has disposed of the writ application filed by the respondent in terms of the order passed in case of Malayananda Sethi, relying on the judgment of the Malayananda Sethi. Now, it's similar matter pending for the Honorable Apex Court in case of Bindu Sagar Samantray and Ruchitra Bhatt, where the issue with respect to the consideration under the old rule and new rule is sub judice. And in similar cases, my lord has passed this order.
Yes.
Item 22.
Item 22. Here there is a delay of 183 days. It's matter related to that Sarath Chandra corridor case. And there, your lordship have issued notice in similar matters.
Item number 24.
There is a delay of 599 days. Here the direction for the consideration of regularization of the contingent paid laborer and consequential release of the financial and pensionary benefits matter. Now, the writ petition filed by the petitioner was disposed of by the Honorable Single Judge, referring to the case of Rasmi Rekha Das. Now, the case of Rasmi Rekha Das, the said judgment is the subject matter of challenge in writ appeal 127 of 2022, where this Honorable Court has been pleased to stay the judgment, and the interim order has been subsequently continued matter, and the matter is sub judice. And our case before this Honorable Court in the present appeal, that Rasmi Rekha Das is a case of appointment through outsourcing basis, and there the Honorable Single Judge directed to regularize their service, considering their continuance against the post. But as such, there was no sanctioned vacant post. And the present case is completely different from that. But however, since the order has been passed, keeping keeping in view the judgment passed in case of Rasmirekha Das. So what I pray, since the Rasmirekha Das, your lordship have stayed, so this matter may.
No, there is delay of. We can decide this Rasmirekha Das. We shall list this matter after 4 weeks. Or we can.
I'm for the capital, my lord.
For the caveator. How can we expedite hearing of this appeal?
Let me solve a copy, my lord. I'm for the
No,
capital.
in this case, WA 127,
My lords.
who is appearing?
State is the appellant. State is the appellant there.
Yeah, we know.
There are the batch of cases. One, B.S. Tripathi is appearing for respondent for Rasmirekha Das. The state is the appellant. B.S. Tripathi and batch of cases.
How many cases have been disposed of?
At least more than 100 cases are tagged that with Rasmirekha Das. If your lordship will fix.
Please make a mention.
Well,
Please let there make a mention as to how many appeals are pending.
Yes, so I'll give that list. That list is with me. My lord, I will give that list tomorrow, and your lordship may fix any date. I'll make a mention tomorrow, my lord. Lordship.
This for 1 week. You are here. You are appearing. Your name is not appearing. So what is there in the name?
I took the liberty of informing my learned friend that the matter is there. That is how he came to know that the matter is there.
Yes, what is this matter about?
And this is that relating to the my lord's rehabilitation assistance, whether on the date of death or the my lord's date of consideration of the application for Malayananda. But I have been informed, my lords, that batch of cases where my lords, the Honorable Supreme Court have issued notice in this Jita Luha case, pending before the Supreme Court on that issue whether Malayananda city decided that on the date of death, the rules prevalent on the date of death, that is the rule which will govern the consideration of the application for my lords, rehabilitation assistance. And our honorable single judge decided, and honorable division bench also confirmed the order. Subsequently, the state government has gone in appeal in a batch of cases. This is, my lords, the Supreme Court has issued notice, and that question is pending for adjudication. I'm not sure my pardon.
So, is there any delay?
Only one copy, if your lordship.
The Honorable Single Judge has directed for consideration of my claim.
And this, but in the facts, sorry, I had just one copy. I thought, your lordship. Batch of cases.
What about the delay? This is item number 45.
My lords, in this case, my lord, in the facts of my case, particularly this case, my lords, we were not heard. The matter was disposed of on the first day. We were respondent number 2, I am the institution, my lords. I was not heard and my order was quashed. My order my lords, giving him marks under the 2020 rules was quashed. So, and 309 days delay was not heard. The order also reflects on the face of it.
To consider my claim on the basis of Malayananda case, man.
In his absence. In his absence.
That is the.
That order was passed in his absence. Then not sustainable. Where is the order?
Order is at, my lords.
Yes, 22.
Annexure 4. Annexure 4.
What state was this?
Writ appeal, my lords, annexure 4. Page 22. Impugned order.
That was hard.
So who had passed this order? 11/11/2022. Next
I had,
six was passed
that's
by whom?
Annexure 3.
Oh, no,
The- Annexure 3 to the writ appeal, we have annexed that order. That was our institute had passed this order.
So we are setting aside this order. Matter and we'll remand the matter back. We will condone the delay.
File book.
ये फाइल वो कल था ना ये there is delay of 9 days. Bring the present appeal, present Infructuous appeal. We have heard in senior counsel appealing on behalf of the Appellate, Odisha. What is that? Odisha?
Odisha University of Technical Technology and Research, OUTR.
OUTR.
No, it's Odisha University of Technology and Research.
Yeah. And learn counsel for the response. Full stop. After having considered the explanation in the application seeking condonation of delay and rival submissions advanced on behalf of the parties, in our opinion, a case is made out for condonation of delay in referring the appeal. Accordingly, the appeal is allowed. Accordingly, this application is allowed. The delay stands condoned. Stop. WA number so and so. This appeal has been preferred, putting to challenge an order dated 20/12/2022, passed in WPC number 34388 of 2022, thereby taking into consideration a decision in case of Malayanand Setti versus State of Odisha, passed by the Supreme Court in civil appeal number 4103 of 2022, disposed of on 25/2022, comma, an order dated 11/11/2022, passed by whom?
The special officer on special duty
By the officer on special duty
of the university.
of University, comma, OUTR has been quashed. So, senior counsel appearing on behalf of the appellant has submitted that no notice was issued before before quashing of the order dated 11/11/2022 to the OUTR, and accordingly the said order was passed in the absence of the university. Stop. This aspect has not been disputed by learned counsel for the respondent. Full stop. Next, since the order dated 2012, impugn order dated 2012-2022 has been passed by the learned single judge, quashing the order dated 11/11/2022 passed by OSD of the university without giving the university an opportunity of hearing. The said order passed by the learned single judge is hereby set aside. Stop. Let set aside. The WPC number 34388 of 2022 stands restored to its original file. So let the same be placed before appropriate assigned bench.
Let my lawyer senior be appear in that case so that.
He will appear.
I will. Wait.
This is allowed. No order.
Item 26.
There is a delay of 35 days. But the issue is with respect to non-submission of the performance appraisal report.
You are issuing notice. Issue notice. Invitation.
Item 27.
27, my lord. This matter related to Nityanand Biswat regarding the regularization of service and grant of pensionary benefit, considering the entire NMR and work charge period. There are similar cases, your lordship have issued notice in similar cases.
Issue notice. Limitation.
28.
Yes.
In 28, all the pension papers have been submitted to the Accountant General for release of final family pension in her favor. Lordship may grant 2 weeks time. In the meantime, that will be regularized. Already submitted.
Till now, the petitioner has not yet been received any final family pension or GPF gratuity, nothing has been disbursed to him.
Accountant General to release, we have submitted, already submitted, then I will pursue the matter.
Please pursue.
Yes, ma'am. Already family pension, provisional family pension has been released. So far as final family pension is concerned, all the papers have been submitted to the accountant. Yes, ma'am. Against an interim order because that personal appearance.
Yes.
So you are.
All right, let us see.
That has been submitted on 4/5.
All right.
Submitted on 4/5/2024. So in the meantime, that will regularize.
Please do it.
Well,
as requested on behalf of the appellant, place this matter on 2 weeks within first 5 cases.
Item 29.
29, date may be fixed. Date may be fixed.
He's asking for well, date is fixed.
Date is fixed and your matter will be taken up after 2 weeks. listed within first 5 cases. So that is the importance which the court gives to your case. Right?
Item 29, my lord, senior counsel, Mr. Manoj Mishra is appearing, your lordship, is out of station, your lordship called, and also I have to file an objection that, they have filed a condemnation of delay. Your lordship, allow me
delay.
1 week.
Your lordship,
495 days.
I am the appellant here.
95 days delay we are
495 days.
delay we can condone.
Your lordship, Mr. Mishra has to argue the matter. your
All
lordship.
right. As requested on behalf of the respondent. One respondent.
Yes, ma'am.
Respond.
Respondent, list this matter when do you want?
1 week. Next week. 1 week after lordship.
At 2 respondents, he is appearing for respondent number 1.
I am for appearing more.
Respondent number 1. Respondent number. So we are liberal in
2 million notice.
condoning delay.
Yeah.
We are liberal in condoning delay.
No, that has to be.
Court is saying that court is liberal to condone the delay and don't get afraid of.
No. That is against him. This observation is against him. Therefore, he is worried.
That is.
He should be afraid of.
Yes.
1 week after.
Item
number 30.
Item 30, my lord, this is also against the one order. I prayed 2 weeks after because in the meantime, I want to resolve the matter outside the courts. So,
Yes. As requested on behalf of the state, does this matter on 2 weeks?
Item 31.
This is a matter relating to recruitment of laboratory technicians. And the qualification prescribed in the advertisement was diploma in medical laboratory technician. So far as the petitioners are concerned, the respondents are concerned, they admittedly did not possess that qualification. They had the certificate of technician certificate with respect to malaria only. But the requirement was laboratory technician.
Where is that?
Both.
Where is the qualification?
Your lordship may kindly have a glance to the advertisement that is at annexure 1.
I mean, pardon me, may I request, on the day before yesterday it was there, my friend was supposed to submit a copy. I don't have the copy. This matter challenged by some other persons in the writ appeal and also in the contempt and just giving, passing out the orders. Other day I could not give it. Kindly have it. The developments in this particular case. There was another three writ appeals by 2 different benches, one by my lord and another by another coordinate division bench. The judgment in these 3, there are 3 cases, my lord. The common judgment was passed by the single judge on 23/8/22. The first one I have given, my lord. In the seriatim.
This is writ appeal.
Yes, my lord. What happened? Just I am facing the facts. This is common judgment. Against this particular judgment, what now it is assailed by the state, it was challenged by before this honorable court by another set of persons in another writ appeal. That writ appeal order is there, my lord. The order was modified by this honorable court. That was in writ appeal 1360. I have given it in serially, my lord. May kindly have a glance, my lord. How the developments? Thereafter.
Yes.
My lord, the first judgment I have given the single bench order.
Yes.
My lord, thereafter, before the single judge.
What was held by the single judge?
Single judge, my lord, the termination was set aside. Direction was issued for reinstatement. This was essentially this was the order.
But my lord,
our service.
Just a minute. Let him. We'll come back to you.
Yes. Yes, qualification we have. As per the advertisement, we are duly appointed, we are continued. And
See,
without,
we are deviating from the procedure.
yes,
He is before us with his appeal.
my lord, I
And
know.
you have started making your submissions.
Only
But-
thing, my lord,
All right, we will do that. We'll
Only-
hear you.
only one.
Let us
Then let
understand.
him submit. Let him.
No, please, let us understand. You
Yes.
may be having some information which he does not have.
But
Let
yes,
us
that
see.
is why I'm just giving. But this order was challenged by some other persons, some private persons. Those are interveners. In writ appeal number 1360, I have given an order, man.
State has not challenged that order.
State was a party. No, state has not challenged. State has now come. Another person, same order was challenged. And the order was passed by a coordinate bench, division bench, on 29/1/24. And this order was modified. Honorable Single Judge order was modified to this extent. Because the other person, they said we are the affected persons, but the Honorable Court says you are continuing, they are also continue. So their right was not affected. Its order was passed. They, in apprehension, they challenge that order. They are intervener in the before the Honorable Single Judge. They say we will be affected, but the court has come to a conclusion. You are not affected. They are regularized in the meantime. Well, I want to kindly have a glance to that order in WPC 1, no, sorry, writ appeal number 1360/22.
No, but this does not affirm the order of the learned single judge.
My respect submission is, my
No, sorry, this submission you cannot make.
it is modified. That time,
There is no modification, is different thing. The state is challenging the order.
all right.
That was challenged by, yes.
My lord, may kindly have a glance to the advertisement that is at annexure 1. The qualification prescribed for laboratory technician, pathology and malaria. That is serial number 4 of the advertisement.
Yes.
The right hand side column, my lord, the
Yes.
qualification, diploma in medical laboratory technology, that is DMLT course from any of 3 medical college hospitals, medical college and hospitals of the state from any other AICT approved institution. This is the prescribed qualification. Now, my lord, so far as the present petitioners are concerned, they possess the qualification of vocational certificate in MLT, which is not similar to the qualification as prescribed in the advertisement. However, their applications were considered and subsequently the appointment was issued. That is on record, undisputed on record. But when later it was pointed out that the petitioners have not possessed the qualification as prescribed in under the advertisement, those appointments, the order of termination was issued. Now, challenging those order of termination, the petitioner approached this honorable court, and the judgment my learned senior was referring to, the lordship, the para 28 is the moot question. Your lordship may kindly have a glance to para 28 of the judgment. Peruse the material available on record. This is the finding. This court, after going through the same, finds that even though in the advertisement issued under Annexure 2, there was no provision for submission of applications by the candidates, save and except the candidates with having diploma in medical laboratory technician from any of the 3 government college and hospital of the state or approved institute. But the applications of the petitioners were not only entertained, but also they were selected.
How much delay?
But there is a delay of this judgment was passed in 2022. We have preferred in 24. So there is
How much cost will you pay?
Yes, my lord.
1 lakh. So we can condone the delay. Seek instructions. Seek instructions. 1 lakh at least, not less than that. Such a sensitive matter, and the person should be prosecuted. If they did not have the qualification, how could they be selected? It's a very serious matter. And without connivance of the officers, It could not have happened. So seek instructions. If you are ready to pay 1 lakh for this court to consider your application for condonation of delay, we will do that. Otherwise, we will dismiss your appeal on this ground. But we shall make strong observations against your officials. It's too much. You know that they were not qualified. You allow them to be appointed. There is an order passed by this court on that ground that because you allowed, you accept that. You don't challenge that for 2 years. So this cannot happen without tacit support of top officials. The court will direct institution of cases against them. We'll take up the matter on Monday. First case. Which department is this?
Health and family welfare.
Family welfare, they are audacious. They must be knowing everything. How many persons have been selected?
Here the petitioners were only three petitioners.
How many persons? Do you have any idea? How many persons having no qualification as mentioned in the advertisement have been selected? Any idea?
Throughout the state, there are many, but here only 3 persons before my lord. There are many, because that is not also fact, what is submitted. Not fact. Yes, we have the qualification as per the government resolution. I will show my lord, let it come on the day.
Sir, you may be having the qualification, but you did not have the qualification as per the advertisement.
There was a guideline for selection, and there was a exception clause, those are passed out from other establishments, because there was a dearth of candidate from this diploma qualification. They have allowed the persons, and now also there are many persons regularized and continue.
There might have been 1 lakh candidates having the qualification who could not have applied because of this stipulation in the advertisement.
No, there was a resolution. 2012, there was a resolution. To that, basing on that, their selection was made. I'll come because I have not received the copy.
Give him copy.
Yeah, not
I'll
received
give
copy.
today. In course of the day.
Let the copies of the memo of appeal and the application seeking condonation of delay be served upon Mr. So-and-so, who appears on behalf of the private. And what about others? Have you filed appeal in other cases?
Yes, they filed.
Yes, we have filed. I'll
That is
the numbers.
I have got the number 1261 and 1327 of 24.
This case on Monday. So what, do you have the number?
I have the number. I have
W,
1261
Monday along with WA number
1261 1327 24.
And you will have to tell us as to how many termination orders have been passed on this ground, and what and whether such in other cases also did applications have been were filed or not. Well, this is obnoxious.
Item number 32.
May I please, Your Lordship. My lord, non-compliance of the order dated 22/2022, my lord. Lord, I have filed also an delay petition, my lord. Already 2 years been elapsed. I have filed an delay.
How much delay?
My lord, 2 years, my lord, delay, my lord. My lord? Yes, my lord. Yes.
Condemnation of delay in filing the contempt application.
Yes, my lord. I filed the delay petition, my lord, in the content petition. I number 304 of 2024.
Yes, it's listed.
So what is the limitation?
Limited, my lord, 2 years, my lord. 2 years, 2 months.
Limitation is 2 years.
Yes, my lord. On 22/2022, the order has been passed. I have filed this application on 22.
Within what time the contempt application was required to be filed? How do you know that there is delay of 2 years? Huh?
Within 1 year, my lord.
Within 1 year. Where is that? Where is that limitation?
I'm not.
And limitation is for what?
Delay I have filed.
Limitation is for you or limitation is for the court?
No, my lord. Only the one plate for that.
The court cannot take cognizance. That is the requirement. So where is the question of condonation? How the court can extend that period? That's different matter. What is the order? Let us see.
My lord. Order is at Annexure 2 series, my lord.
Page 11.
Page 11, my lord.
Seek instructions. 4 weeks time is allowed to blend AGA appearing on behalf of the contenders to seek instructions as regards compliance of this court's order dated 28/2022 passed in WPC bracketed PIL number 3037 of 2020.
Item number 33.
Obligement.
Lord, here under Annexure 1, the order of the tribunal is under challenge.
Presently, tendency of the equipment management is changed. So in place of DESCO, the new management Tata Power has taken over management. So any order, any order, so I pay the substituted, the successive management be substituted Tata Power.
Lord, on my oral submission, if a lordship may allow, it is only to be, my lord, substitute. Name is only to be substituted. If a lordship permit, I will file substitution.
This is our general knowledge.
Old case, that is why, my lord, I may.
Amended cost title.
Whole case will take hardly a week for you to
Well,
file the
if a
petition
lordship
in order
will
to be
file
passed.
I requested on behalf of the petitioner list this matter on 1 week.
Item 34.
What?
34 and 35 same, that encroachment of government land. The old case, they must have been evicted, I think.
Encroachment of street vendors.
Not street vendors, they have encroached. According to them, we have said that they are not street
Oh,
vendors.
that's it.
Item 34.
33, 34.
No, 34, 35 are
Same, 34, 35, same.
35.
street vendors.
This is under in Baleswar town.
Item 36.
Dismiss.
Dismiss for default.
Yes.
Item 36.
Anything remains in that?
Dismiss a default. By one of you.
37.
From 37,
Can it be taken up some other day? Can it be taken up some other day, Monday or Tuesday?
Where is the order? So if our orders are published in the media, then the world will laugh at us. Every time you have taken adjournment.
30, I am for the managing committee, Kamala.
No, you're the appellant. You're the appellant.
Yes.
Yes. You have not taken time.
Yes.
That is what we are saying. So many adjournments, that is what we are saying.
37 or 38, that is I am confusing. I'm in WA number.
We will not grant any adjournment.
Misra has some problem.
Let us see the order which is under challenge.
Last six.
Taken up after lunch.
32 orders have been passed. 31 orders have been passed.
Last 6 orders at your instance. Last 6 adjournments at your instance.
Okay.
Yes.
WA number 264 of 2007. Yes.
Let us see the order which you have challenged.
Yeah. 54.
Speak for the grants. The order, last order, Miller. This is page 54. Page 54 operating person is.
So what, that managing committee is still in existence?
Yes, yes. College is still existent.
The college is there. That same managing committee is there.
Now college is a error institution. So the managing committee is governed by the secretary principal. The principal is the secretary of the.
This is of 1985-86.
Yes, the question,
It has become.
the question is Miller, only for the purpose of giving an antedated recognition. College has.
What can be done now for 84-85?
Difficult.
Now we understand the reason why you were seeking adjournment. One after the other.
Mr. Mishra, senior counsel, is appearing in this case.
He is here. He is appearing.
But I think we have, this matter has been heard, the other bench. But that was understanding that the single judge order should be maintained. But I don't want to interfere that. You should dispose of. Because we have also decided that cannot be done retrospectively. That was the argument that was also I advanced. And your lordship indicated about the UP matter and all those things. Here also the same thing happened. Supreme Court has said you cannot admit student without being recognized. That's a plain and simple.
An order dated 15/7/2017, passed in WPC number 9449 of 2017, is under challenge in the present intra-court appeal. Most of you have heard Mr. Mishra and senior counsel hearing on behalf of the appellant and Mr. You are appearing.
So Samantra, you are there?
No,
Someone is there.
Mr. Khutia.
Somebody for the state has to be there.
Oh, sir.
37.
Patnaik.
Mr. Khutia is, I think.
Oh, that is, yes, Mr. Khuntia is there.
It appears that the petitioning institution had filed the writ application seeking direction inter alia to accord permission to the college in question with effect college in question retrospectively right from the session 1985-86. and single judge has based on the materials available on the court has reached a conclusion that the college was non-existent in 1985-86 and permission was accorded to the college for the session 2002-2003 for the first time. For the first time,
2001 and 2001 and 2002, there's a typing mistake in the single judge order. My lord. If your lordship looks at page 58.
Between type 2 and 3.
all right.
2 and 3.
2001 or 2000.
2000. So after having gone through the review order, we do not find any such legal infirmity requiring this court to interfere in an intra-court appeal. This appeal is accordingly dismissed.
Disposed of, your
lordship, one correction. College
Never do that.
No, I am not. The only thing, college was given permission in 90, but recognition was given.
Recognition was.
We have said my recognition.
Item number 38.
And never do that.
No.
If you have to say something, you should tell your senior. And whatever is to be conveyed to the court, that is to be conveyed to the court through the senior. Once you have engaged a senior.
Yes.
That should be.
My lord, in item 38.
Can take 2 weeks after.
Lordship, may kindly note that in obedience to the order dated 3rd January 2024, we have filed the affidavit. The government has filed the affidavit on 2nd February 2020. That's
Copy.
I will give copy.
Where is Mr. Mishra? He's gone abroad?
Out of state.
Out of state, country, or what?
Out of country.
He has gone abroad.
After the weather improves, he'll come back.
He will come. No. Otherwise, he
should have been from the very first.
From the very beginning.
He should have been here. Otherwise.
Sure.
Ticket done. When?
1 week after.
4 weeks after.
4 weeks.
How?
2017.
Again.
After he comes, you have to serve a copy.
Yes, I will.
What is your affidavit?
This is 2nd February.
No, what have you
stated in the affidavit?
Para 3 at page 2, mechanics. In response to the said order, it is submitted that Collector Bolangir in their letter number so has submitted, though minimum crop loss of 33% and above have been found by the Tahsildar in the Gram Panchayats and Patnagad, Khaprakol and Belpad blocks during Kharif, an input subsidy under SDRF has been paid to the affected farmers. The claim under crop insurance paid to farmers is between so and so to so and so. That it is submitted
the
that.
company.
My lord?
Between so and so means what?
0.423% to 32.799%.
That means that is less.
That it is submitted that the calculation for providing input subsidy under SDRF and the calculation for payment of claim under crop insurance scheme are altogether different.
Different things.
These are two different. That was the issue which was raised by him. These are two different. That is the affidavit. Yet that your lordship is to consider at the time of final hearing. This
Your Lordship, here the crop insurance runs under a particular scheme, Your Lordship. And this scheme he has also provided in Annexure 1. And nothing can be beyond this scheme, Your Lordship. Here a prayer is made beyond the scheme and it is confused with the subsidy, Your Lordship. That is the entire thing here.
No, but we don't grant adjournment on such grounds. This matter is of 2017.
Only 2 weeks.
Whether earlier.
Have you served copy of the affidavit on Mr. Mishra?
That not served on my learned senior Mr. Mishra, but the office note says that it is served on petitioner.
Petition.
It is served on Mr.
HS Mishra.
HS Mishra.
No, I would be called. Again, I am serving today also to the junior.
Requested
I will.
on behalf of the petitioner. Is this matter on 2 weeks? So we make it clear that since the matter is pending for since 2017, no further adjournments have been granted. We also take note of the fact that a counter affidavit has been filed.
Not
Not counter. This is the affidavit in response to the order of the, in obedience to the order. An affidavit from the
has been
government.
filed in compliance of this court's order.
Dated
Yes.
3rd
3rd
January.
January.
3rd January 2024.
3rd January. Yes.
Item number 39.
Your Lordship, in item number 39, I am appearing on behalf of the petitioners. In this case, Your Lordship, we had filed a PIL as to the illegal slaughtering of cows at various places in Cuttack. With respect to that, this Honorable Court had directed this Cuttack Municipal Corporation to take necessary action and give us the details as to the necessary slaughter houses that have been created so that the unnecessary and illegal shops and the unnecessary pollution can be controlled. So with respect to that, they had filed an affidavit. It filed an affidavit on the last occasion. However, they had been asked again on that date, that is on 5th February 2024, to file another affidavit.
Which order?
Order number 30, Your Lordship. Order dated 5th February 2024.
There is no order.
Order number 30.
File देखना.
So
30.
the direction was given on 31/2024 in compliance to that order, my lord. We had filed an affidavit on 5th February.
It's all right. I have.
Yes.
Complying the honorable court's direction, my lord, we have already filed the affidavit on 5/2/2024. Your lordship may kindly see the affidavit that was taken on record. We have
5/2,
mentioned in
sir.
detail the figures, my lord, and the fines collected and all the steps taken by the CMC to prevent the slaughtering, my lords.
Wrong has been committed.
What do you want?
Your Lordship, now the CMC has come up with a plan wherein they have stated as to where the slaughterhouses are being created and the areas that have been identified. So if that can be carried out, my grievance would be yes. There's nothing more up after that.
And where is your plan?
Well, that we have already indicated in the affidavit, the steps and all the proposal that have been taken place. All the places have been identified. My lord, at paragraph 4 of the affidavit, my lord, may kindly.
4 of affidavit filed on 5/2.
5/2, my lord. Places have been identified, my lord.
That means this 120 cases which you have said, they were doing illegal slaughtering or illegal selling?
Illegal slaughtering. So fines have been collected.
Just in 1 month, so many cases.
My lord, 3 months, December to February. Special squad.
Oh, not only that, chicken center also.
My lord, chicken also.
So instead of stopping them, you have been collecting fines.
No, my lord, they have been stopped also wherever they are identifying and also collecting fines, and also in the same time they have also identified some places for
them.
small and big animals.
The present writ petition in the nature of public interest litigation has been filed for a removal of unauthorized and illegal slaughterhouses and for prevention of cow slaughter in accordance with the restrictions stipulated in Odisha Prevention of Cow Slaughter Act 1960, as also to regulate transportation of cows in Cuttack, more particularly in the area of Odia Bazar, Janta Gali, Hathi Pokri, and Devan Bazar under Cuttack Municipal Corporation. Stop. Next, the petitioner claims to be a society registered under the Societies Registration Act. Your office is in New Delhi.
Yes, sir.
You have your office in New Delhi.
Yes, Lord.
And you have come from there. Stop. Next, pursuant to an order passed by this court in the present matter, what is IIC? What is IIC? You said
Inspector in charge.
Inspector in charge, Dargah Bazar case, IIC.
Inspector in charge, police inspector.
Police inspector, like SHO.
Police inspector in charge of Dargah Bazar police station has filed an affidavit. Where have you filed?
On 9th February 2024.
On 9/2/2024. Where is your plan?
No, the direction was to furnish the details of the cases pending and the status of the cases. IIC is to furnish. That we have furnished in that affidavit.
No, do you have any plan to stop it?
That CMC has.
That we have already, my lord, stated that if your lordship may see para 4 and 5, with assistance of CDA, my lord, steps have been taken.
No, you will have to have comprehensive plan.
My lord, that my lord, process is underway, my lord. They are my lord, identifying the places for that.
They are identifying.
My lord.
Since 2018.
My lord, they are my lord.
Have you?
Lordship may stipulate some time period, my lord. It will be.
What is this? Then what have you been doing for all these years?
The earlier places that were identified, that was there because of public objection,
public blood for slaughtering of this big animal. But somewhere a religion issue, communal issue arises, they object. So that is why you are facing difficulty. Then we have identified an outscript with town ultimately.
Where is that affidavit?
Separately, you have seen that.
See, Mr., we have to stick to law.
Right.
If the law commands us to do something, we will have to follow that. One or two instances of taking some action will not do. You will have to have some comprehensive plan. Act.
Unless you do, they'll continue this illegal selling, illegal transportation practice.
That we have indicated in an affidavit dated 18/7/2023.
I think there was one slaughterhouse near the stadium that has been closed since long.
That is clear.
That is Kilkhana near.
Let's may kindly look at
Para 7 of the affidavit dated
para 7 of the affidavit dated
18/7/2020.
No, have you stated that which place you have identified or what? Because this will continue.
in the last affidavit we said what problem we faced that we have indicated in 18/7/23 affidavit. Then lastly we have said that on 5/2 in para 4.
Next affidavit is date and date. Detail about it, one will know the date. Next affidavit dated person.
So whether you are following the provisions of law or not, provisions of this act or not. That is the whole issue.
Yes.
Let us come to section. Please examine. Do not leave the issue like that. We were under the impression that you have prepared some comprehensive plan to implement the provisions of the act. And
বহি না বহি দরকার এই নিন।
whether CMC has filed any affidavit disclosing any plan to implement this provision, or this provision is being followed or not.
So kindly see the paragraph 4. Paragraph 4 of this affidavit dated 5/2/24.
5/2/24.
24.
5/2 or 5/9/2?
5/2/24
filed by whom?
5th February 24.
Filed by whom?
It's filed by the Deputy Commissioner, Ajay Kumar Mahan.
Yes.
Mine. Well, at paragraph 4. That as has been submitted in the previous affidavit dated 30/1/24. In the meantime, 6 numbers of places, that is at Dewan Bazar, Khalasi Lane near Cantonment, then Pratap Nagari, Satrol, Jobra, and Imam Nagar have also been identified in the same area for construction of new slaughterhouses. Out of above 6 places at Dewan Bazar and Khalasi Lane near Cantonment, there is proposal for construction of slaughterhouses for big animals like cattle. However, at other 4 places, there is a proposal for slaughterhouse for small animals like goats and sheep. In this connection also has been mentioned in the previous affidavit dated 31/24. The land so identified, selected at Dewan Bazar belongs to Cuttack Municipal Corporation. However, at other 5 places, the land so identified, selected.
So you have identified the land.
Yes. And for small animals, we have slaughterhouse.
We are going to put a very difficult question to you. You read section 3.
Section 13.
Do you have the act? You have the act with you.
I have given the act.
All right. Certifying that it was.
Corporation Act adoption na? Corporation Act.
The act provides for any place to be specified for slaughter. It says each animal which is slaughtered, you have to give a certificate.
That is right.
So have you given one certificate?
But that aspect I have not
So
examined.
till date, has any certificate been given for slaughter?
That aspect, fairly submitting, I am not.
All right.
That
This-
issue has
this-
not come ever.
List this matter on 1 week to be within first 5 cases. 1 week. 1 week this matter on. And so who heads the CMC?
Pardon?
Commission. The commissioner. Cuttack Municipal Corporation shall be obliged to file an affidavit stating as to how many certificates have so far been issued in accordance with the provision, accordance with Rule 3 of the Odisha Prevention of Cow Slaughter Act 1960.
Section.
Rule.
Act.
Section. Form you are-
The form is written rule 3. The act is. The form says rule 3. So rule, so both,
That is because of
both.
Rule 3.
Yes.
Section 3 and then
And
Rule 3 of Odisha Prevention of Cow Slaughter Rules 1966 in Form 1.
I think, Mr. Mahanti, you check out the Municipality Act.
That is what.
There is a provision.
It is what it was striking to my mind. It is subject to.
No,
in
not
consonance
subject.
that-
There the areas may be specified, how you
Yes.
will control.
Well, that subject to Municipal Corporation Act also, whatever that is provided under.
No, this you have to comply. For a space
yes,
that will be
right.
under the Municipal Act, how can you not comply with this?
That is right. I will
Let us
examine,
see.
but I am not
Not
thorough.
All right.
I will
Please.
examine.
See, please examine the act
Yes,
and we have to religiously follow
Right.
what is there under the act.
yes.
All right.
Well, let's say fixing any.
1 week
1 week.
after one. Simple affidavit. How many
2 weeks,
certificates?
let's say can give.
No, you have to file a simple affidavit because we will have to chalk out a plan
Yes,
as to how shall we move. So if you file an affidavit that so far no certificate has been issued, then we shall presume that this CMC does not know about the law, or there is no implementation at all
Yes.
of the law. Then if you say that yes, in the 100 certificates have been issued or something has been done, then the matter will be different. So this is only for the purpose of the line of action which this court will take in this matter. This order has been passed for you to.
It is only in respect of cows.
Yes, because that is in respect of cows
Present.
for the present.
But so far
Correct.
the other animals are there.
We will consider that. We will consider that.
You are fixing any date or 1 week?
1 week means 1 week. Means you can calculate. You will get the date also in our order.
Right.
The dates are mentioned. We just, for the convenience of dictation, we say 1 week.
I can get the copy downloaded.
Yes,
copy.
yes.
Or let me give a copy directly.
You will get it.
Evening you'll get it.
Item number 40.
Last order.
I am appearing for respondent number 5.
Senior counsel was supposed to go through those decisions.
Yes.
Is it there?
Last occasion.
Online version we will get?
What is there in Bina Pani Sahu?
Mr. Khuntia,
That is regarding my residential, Anganwadi residential area. Residential area, Anganwadi center area. On the last occasion, my learned senior was appealed for appellants. He had disputed that she belongs to that village. The entire case is that lady, though she could more mark, does not belong to that Anganwadi center area. So she was not selected. So your lordship last week asked me how he is covered by that. Even if he belongs to that village, can she be considered? No.
Yes.
No
You are
one
for
is
the-
appealing for appellant's matter.
I am for the respondent 5.
Who is for the appellant?
Mr. Gautam Acharya, senior counsel, my name appears in the list, is not appearing. इसमें ठीक से another
There is no representation on behalf of the appellant. List this matter on Monday.
Item 41.
Item 41, my lord, on the previous date, notices were issued to the central government and the state government. The counter affidavits are yet to be filed.
I am for the bank, Lord, opposite party 3. I am for the bank, opposite party 3.
P3 is the pro forma party. Main respondent is OP number 1 and OP number 2. Impugned order is passed by the OP number 2, my lords.
Who is OP number 2?
Regional Controller of Mines.
I am appearing for the OP number 2, my lord. Your lordship kindly have a glance to order dated 25th 11/2020. The issue notice to the opposite party on the question of admission. It is the last order.
Yes,
So
sir.
therefore, we cannot proceed. So either admit or is this your submission?
No, we have not received instructions. Only we have received the notice, but
Notes out the copy.
4 years, Mr.
yes, 4 years, but
We may not allow you to further time to file affidavit.
After 2020, first time it was listed, let me obtain instruction.
Therefore, you will not file.
No, I will file, definitely will file my, since we have received the notice.
Don't file, we are not very much. We cannot compel you to file affidavit.
We will file, we will file.
Why not? MCDR, Mineral Conservation and Development. Mineral Conservation and Development Rules. What is there in Rule 27?
Rule 27, my lord. Mining holders, mining leaseholders submit a financial assurance in the form of a BG. There is a procedure how it can be forfeited. A show cause notice has to be there. There has to be a hearing. 30 days time has to be given. What they have done is on 16/3/2020, just prior to COVID, they issued the show cause notice. They issued the final order on 30th/3/2020. 30 days period is not given. No hearing is done. It is done at the peak of the COVID lockdown period.
What is that? Where is that order?
27/5.
The provision letter. 20.
Rule 27/5 of the MCDR matters.
No, which is the rule which authorizes?
My lord, Rule 27 of the MCDR, Mineral Conservation and Development Rules 2017.
So therefore,
my lord, Rule 27(4), my lord.
4.
Sub-rule 4, my lord. If the authorized officer, as the case may be, has reasonable grounds for believing that the protective reclamation rehabilitation measures as envisaged in the progressive mine closure plan contained in the approved mining plan or final mining in respect of which financial assurance was furnished has not been or will not be carried out in accordance with the mining plans, shall give the lessee a written notice of his intention to issue the orders for forfeiting the assured at least 30 days prior to the date of order.
When was the notice issued?
On 16/3.
And when was the order passed?
30th/3.
We will set aside the order. It will come on Monday. Monday. What is this matter on? In the second half, we will rise at 3:30.
Item 42 may be adjourned on behalf of Mr. Sambit Samal. He is ill today. Item 42.
Make a mention after.
Can you hear us, Mr. Jenna? Can you hear us? He has been muted. We can't hear him.
Mr. Jenna, are you muted? Mr. Jenna, you can't hear us.
फोन करी पचारंतु सुबुची कि नहीं
फोन करने बाहर जाएगा
फोन कर दे
Yes, the chief secretary is online, but I don't know if he is able to hear us.
Yes,
Are you able to hear us, Mr. Yenna?
He is not hearing because he is not responding.
Phone. Jayachandra.
yes, just gone to telephone.
Mr. Chief Secretary, can you hear us?
So audio connect
not connected their audio system.
So phone, our phone you inform.
No, on their side they connect. Only they have joined the video, not connected to their audio system.
Yes, if madam bit this is unable to.
So can't be. Unless you inform over telephone, he won't know what problem.
Government advert has gone to inform over telephone.
Theta pite ho, 13 pite ho, and the other one also pite ho.
कौन
Mr. Jenna, can you hear us?
Same thing also.
Then we'll ask him to connect over phone or what to do. This will happen like this.
This is the position.
He's trying to say something, but I think he's muted.
Lunchtime you should have tested if.
Yeah, right.
We can't hear you, Mr. Jenna.
May try not so
Yes,
early.
please. Sedu karna. Other one is 51. $51 is your affidavit. Have you filed? 51.
51 the affidavit we have filed an application IA number 17462 of 2023, which is at flag B.
For what?
That the steps taken by the state government for formulation of this litigation policy, and we sought for certain time to complete, because in the meanwhile there are some changes. So will that your lordship may see flag B, IA number 17462 of 2023, the resolution of the state government, and also annexed as Annexure A.
So you want us to allow this application?
No, that we have substantially, the Chief Secretary is also there. We have substantially progressed that only the state litigation policy, this same has been vetted by the law department. Now it is to be finalized by the government. So in that IA, we have only 3 months time we had sought for.
Granted.
3 months must be over.
Granted.
That is over.
We grant you 3 months time. We allow your application.
But that is already expired. But because of this some internal development, another last chance may be given. I think that will be completed.
What about this?
That is state litigation policy.
Is unable to join?
That is because he can.
This is the technical help he is getting.
No, sir. I don't know. System is not.
There is something error in the system, I think.
They could have stand by on a. In fact, I talked to even our law secretary also, so that he can.
What will happen if you speak to the law secretary?
No, he will intimate at least that.
Not directly. Yes, that we will ensure.
In lunchtime.
The chief secretary has, State of Orissa has joined online. Apparently because of certain technical glitch. The court is a technical glitch. He is not able to address this court. So does this matter on next week?
Yes.
Next question.
He has tried to get it with mobile, I think.
Mobile, yes.
Sir, am I audible now, sir?
Now you are audible.
Sir, I'm sorry, sir. There is a technical problem from this end, possibly. So, sir, I couldn't. Now I am connecting from my mobile, sir.
So we will take up that matter suo motu application, suo motu proceeding later.
Sir.
But tell us, we are worried about a situation where so many cases are pending, contempt applications are pending because of failure on the part of the officials to dispose of representations.
Sir.
So what do you propose to do?
Sir, I'll take 1 minute to, sir, there are about 13,000 contempt cases, sir, of which 8,000 have been instituted in last 2 years, sir, after the abolition of the tribunal. Certainly the case load has improved, has gone up, sir. So total about 13,000 contempt cases have been there. Sir, in last 4 months, we have tried to dispose of about 1,000 cases, sir. Sir, there is a need to further intensify our effort to dispose of these cases, sir. Sir, in the meanwhile, we are almost reviewing it every month. And sir, what we have discussed with the 2 things we have done, sir. Under our litigation management system now, sir, we are able to get the information from the court regularly, and therefore we will be in a position to address it. There are 3 kinds of issues, sir. Issue 1 is representations which have unfortunately not been disposed of. So we are now working out a system whereby in next 2 to 3 months we'll try to dispose of all those representation contempts relating to representations. Non-disposal of representations.
Let us confine ourselves to this situation.
Sir,
we will consider other aspects later. Let us confine to this situation where there are orders passed by this court for disposal of representations. Please do that first. We will come to any other point later.
Okay.
That is one of the biggest challenges which we are facing.
Sir.
So just give us a timeline. You can say 1 month from today. We will grant you 1 month from today. From 1 month within 1 month from today, all such representations which are to be disposed of by judicial order must be disposed of.
Sir, may I request, sir, if in place of 1 month, sir, if I can be given 3 months so that I will ensure that
3 months. No, the directions were issued about 2 years ago for disposal of representation within 3 months. You are seeking today. We cannot see, Mr. Jena, our problem is that if you don't comply with the order, then we have to initiate contempt proceeding against the officials. the direction, we cannot modify the judicial orders. If there is judicial order for disposal of representation within 3 months, you are under obligation to comply with that. You are disposing of representations after 1 year or so. We are just very you may say very kind to your officers. We are not taking. We have not taken any action so far. So you cannot the 1 month maximum we can give. Otherwise, we will have no option but to proceed against the officials. So when we start contempt proceeding, they comply with the order. And you are seeking 3 months. 3 months is not acceptable. So within 1 month, ask your officials if any representation is pending which is required to be disposed of because of any judicial order of this court, that must be disposed of within 1 month. So you tell your officials. Tell you this I have from February as Chief Justice I have been insisting the officials to do it. Otherwise, this is just a suggestion. If you don't do, you are free not to do.
No, sir, we will not, sir, we can't disobey the orders of the Honorable Chief Justice, Honorable High Court also, sir. Sir, this has to be done. I take the responsibility of that, sir. I take the entire blame that we have not been able to do it, sir. Since the number is little huge, sir, that's why I was requesting for some more time, sir.
That number for us also is very huge.
Sir.
It will not recur, but we will have to address the pending contempt matters.
Sir. Sir, Director, we will certainly try our best to comply to this.
All right, we'll take up this matter on after 4 weeks. In the meanwhile, we will see. The Chief Secretary, State of Orissa, has joined the court proceedings online. And he has informed the court that he shall issue necessary directions you will issue necessary directions.
Sir, I will issue necessary directions. Sir, tomorrow I am going to call all the secretaries and have a meeting and impress upon the concerns of Honorable Chief Justice, sir. And I will request them, and also then every week I will monitor myself, sir.
The Chief Secretary has informed this court that he will hold a meeting tomorrow with all the departmental secretaries of the various departments of the state government to impress upon them to ensure that the court's orders, particularly relating to disposal of representations, are complied with as soon as possible. He has also assured this court that he shall monitor implementation of the orders of this court by the government officials on weekly basis.
Sir.
List this matter on 5 weeks. On which date an affidavit 5 weeks an affidavit will be required to be filed, sworn by who will swear the affidavit? Who will swear the affidavit?
Sir, our additional Chief Secretary, General Administration Department will file the affidavit.
Sworn by the General Administration Department, stating as to in how many cases such representations have been disposed of, referring to the case numbers of such contempt matters. 5 weeks. Yes, thank you.
Item number 51 is also.
51 will be listed, but we are not passing any order in 51. We have passed order in 30.
It will also be listed after 5.
5 weeks along with. IA stands disposed of. IA number 5 stands disposed of as having become infructuous.
Mr. Mahanti,
Yes.
that IA disposed of?
There is another IA. Thereafter another IA is
That
filed.
is also January 2024.
January 2024. Yes, that can be disposed of.
As infructuous.
As infructuous.
Till 5 weeks.
No, sorry.
518 of 20.
That we have, that.
Since it is being adjourned, you comply with
Yes,
that
in
time.
that meantime, you can file an another application.
Answer thorough.
Dayananda Basti. Oh.
That first after.
Item number 23.
My lord, item number 23, I am for the respondent. Your lordship, you are hearing on the question of limited condonation of delay, my lord. There are 220 days delay. And in the order dated 30th of April 2024, your lordship has directed me, the respondent, to make my response, my lord. Because pursuant to a judgment cited by the respondent, the appellant counsel, my lord, law and counsel, cited a Supreme Court judgment relating to Bhubaneswar Development Authority, where the Honorable Apex Court has condoned delay. That your lordship kindly see order number 7. Or your lordship I will proceed to give my response.
May I submit my
Surana Manjari, there is absolutely nothing in Surma Manjari. Surma Manjari was a case where an application was filed before the administrative tribunal. An order passed by the administrative tribunal was under challenge before this court. So this court did not have any occasion to consider condonation or delay under Section 5 of the Limitation Act. That was a different matter altogether.
No, your lordship wanted me to respond to paragraph 4, my lord, of the order, my lord.
Yes, yes. So you must have seen.
Yes, my lord.
Bhubaneswar Development Authority. Yes.
This, my lord, my submission to lordship is this is a completely distinguishable case, my lord. Here, my lord,
completely
a particular caste certificate. Here, my lord, caste certificate before the Honorable Supreme
No, that
Court.
is not the question. The question is of condonation of delay only.
Yes, my
that
lord.
has to be condoned or not. That is the question.
That is the. So my.
That.
Yes, my lord. My lord, my.
Yes, we can condone the delay. How much delay is there?
220
My
days.
lord, 220 days, my lord.
Yes,
That too,
we can condone the delay. We can impose cost on them.
Pardon?
We can impose cost on them. Or we can condone the delay after imposition of. That can be done.
My lord, the grounds, according to my humble submission, grounds stated, my lord, are not reasonable grounds, my lord.
All right.
Your lordship will see they have constituted a committee to dispose of the whether there will be appeal or not. And your lordship would kindly see they have taken so many days, 6 months time to constitute a committee. That I will show to your lordship from their affidavit.
Constitute a committee for what?
For whether to file an appeal or not.
So
That your
therefore we are imposing cost.
My lord, they are very lowly placed employees. Regularization is under challenge.
We'll see, we'll hear you on merits later.
All right, my lord.
Yes, where is your IA application?
That's my IA. Number 6152/2023, my lords.
IA number 6152 of 2023. This application has been filed for condonation of delay in making this application, this appeal.
Yeah.
Stopped. Admittedly, there is delay of 220 days. 228 days in preferring the appeal. Stop. The following is the explanation given in the application seeking condonation of delay. Stop. 4, 5, paragraph 4, paragraphs 4, 5, 6, 7. Stop. Next, we have heard learned counsel for the petitioner, for the appellant, and learned senior counsel representing the respondent. Stop. Learned counsel, learned senior counsel representing the respondent has vehemently argued that the delay in preferring the appeal has not been duly explained, has not been satisfactorily explained, and therefore the prayer for condonation of delay deserves to be rejected. Also, he has relied on this court's decision in case of which Manjari? In case of State of Odisha versus Surma Manjari Das, decided on 16/7/2021 in WPC number 15763 of 2021. Stop. And counsel appearing on behalf of the appellant has, on the other hand, placed reliance on the Supreme Court's decision in case of Bhubaneswar Development Authority versus Madhumita Das and others, reported in 2023 SCC Online SC 977, with special reference to paragraph 12 thereof. Do you have that decision?
12 and 14.
Huh? Oh, next. After having considered in our considered opinion, the case of state of in case of State of Odisha versus Surma Manjari bracketed Supra, the issue of condonation of delay under Section 5 of the Limitation Act the question of was not under consideration. Question was not under consideration. So stop. Be that as it may, comma, in view of the facts and circumstances, we consider it expedient in the interest of justice to allow this application for condonation or delay subject to payment of cost of rupees 20,000 to be paid to the respondent within 1 month, from today. So stop. Delay. I number 12 stands allowed accordingly. The delay stands controlled. Yeah, okay. Chandra Kumar.
Yes.
Have you examined L. Chandra Kumar?
L. Chandra Kumar, my lords.
Whether in L. Chandra Kumar any time limit has been prescribed?
Was there L. Chandra Kumar, my lords? To my knowledge, my lords, I have to go through it again, my lords.
And there cannot be any limitation filing writ petition.
There cannot be any limitation. That is well settled position. But in view of this Surama Manjari, my lords, all these things have come up.
Surama Manjari has no application
Here
in cases under
there otherwise, my
Section
lords,
5 of the limitation.
otherwise, my lords, honorable court has ample power to consider the matter subject to condition that yes, there is sufficient cause.
Surama Manjari will have no application in the matters of condonation of delay under Section 5 of the limitation.
Yes, my lords. That is the thing, man. So far, paragraph 14, that decision I relied upon, Honorable Supreme Court said, well, it involves a point of law also, this delay can be.
All right. Yes.
No, my lord, in this case, my lord, actually, the Supreme Court, my lord, observed that an imposter would be occupying a post. That is the main consideration.
We will consider, consider your the appeal on merits. All right. It will come for admission now.
May I play, my lords? Similar 6 cases. One case has been listed. Other cases were directed to tagged up. It not been tagged up. It can be taken up, my lords. Can be, the same order can be passed.
Has anybody appeared for the other side?
My lord senior.
So we let him.
There are 5 other cases, Mr. Patnaik.
Let them serve the appeal copy.
Then they have served copy. They have not.
We have not appeared in those cases.
No, no,
Mr. Patnaik?
Then it may be-
I have not appeared.
Then it will be listed, my lord. It cannot be. It will not be fair, my lord.
You can serve copies then.
If it has not been listed, notice has not been introduced, I have not served the copy, it should not be taken up.
Serve a copy first.
Yes, my lord. It should be taken up on stairs.
Give the
Separate.
list, then it can.
That matter may be listed.
First serve copy.
Yes, ma'am.
And then give the
Yes,
list,
yes, ma'am.
and then we'll. Yes.
Item 42.
Urgent copy, my lord.
Urgent copy.
Certified because now they have to release the money.
No, you get copy without.
Just a minute. Just a minute. Just a minute. Why urgent copy?
Certified copy, my lord. Urgent copy in the sense certified copy.
Apply online.
Apply online, my lord. Yes,
You apply online, you will get the order, and you must inform me on Monday that you got that.
Oh,
So you-
that's all right. Because I have to communicate it, my lord. This will be compliant.
Item number 42.
On behalf of Mr. Subramanian, is ill today or some personal difficulty. So this matter may be taken up on, after 1 week. I am for the petitioner,
42.
my lord.
Who is ill?
Mr. Sambit Samal.
Who is also for the petitioner?
No. Petitioner is Mitra Bhanu Mahapatra.
He is ill.
Mr. Samal is it?
Yes. So you are saying he's ill and you're also saying he has personal difficulty? What is the?
Ill for personal difficulty.
Huh?
Actually, what happened yesterday night at Noyagarh, his close relative happened a road accident. So he goes to late night at near about 1 p.m., 1 a.m. To escape him. So this is the actually fact of the case. So he begged to time for.
This is PIL.
My lord, sorry, my lord, but I am not thorough about this matter. So this matter may be taken over one day after, one week after.
Toll gates, what I have understood, toll gates are operating
toll
given
gate
the period.
Lordship has taken the judicial notice.
Yes.
Regarding bad condition of the road. There are some pothole. And the Channel Court has issued a direction to, I personally visited, did then run an AGA, now Justice Sahu, along with and the petitioner council visited the entire spot. And after visiting, we have filed the case status report day by day of each monthly. And the road condition has been ultimately have come to the roadable condition. There is no difficulty. Ultimately, my lord has in 21/6/23 order, we have filed 2 videography. I have 1 filed by the NHA and the petition also filed 1 videography. My lord has already recorded in the record. And when my Justice Roth was sitting with the Justice Tarapatar, there is a 21/6 order was passed. 2 video clip of a file that is being kept in the my lord's file. Now the roadable condition is the very proper and there is no difficulty for the flying the vehicle on the road. So far the other part is concerned, the other party has never pressed till date from 2021. Now seeking, though they have pleaded in the petition there is existence of toll plaza within 60 kilometers, but there is as per the rules, because the rules provides for if there is the bridges and other things, then on the toll plaza can be within 60 kilometers on the same space of line. Therefore, now the road is almost completed and the local demand of local public, my lord. Now we have opening some underpass 3 to 4 places. That is that work is now left out.
Were you supposed to file any affidavit or
Yes,
anything?
my
Or
lord
it is
said I
ready?
can file.
No. Were you supposed to file? Because again you will ask for time. That is why we are asking.
Last occasion, my lord has lordship has kept. Last occasion, my lord friend has taken time. But the Lord Central Government Council has filed the Union of India for the file counter. We have filed counter everything.
Where is he?
We are sitting here.
On behalf of the petitioner list is later on. 1 week.
Number 43.
Yes, my lord, if you know lordship admin, I can file a complete affidavit again after status report.
Let us see.
Item 43.
Your Lordship, item 43, 2 to 3 weeks to file a rejoinder affidavit.
When was the counter affidavit filed?
Your Lordship, April.
Huh?
April.
When was the counter affidavit filed?
Your Lordship, April.
Huh?
18 April 2024.
Yes, we can hear it. As requested on behalf of the petitioner, this matter on 3 weeks, so as to enable her to file rejoinder to the counter affidavit filed on behalf of opposite parties number 2 and 3.
44.
Obliged.
Item 44.
You have to file the rejoinder to which counter affidavit?
1.
1.
Copy number 1 and 2 and 3 have also filed a counter affidavit.
No. Rejoinder to which counter affidavit?
1.
File on behalf of 1.
44.
My lord, item 44, to which time may be going to file rejoinder affidavit.
Rejoinder. To which counter affidavit?
OP 1 to 4, my lord. OP 1 to 4.
But there is one incomplete. See.
Counter affidavit on behalf of 1, 2, 3, and 4.
Yes, my lord.
Counter affidavits. There are 2 affidavits.
Yes, my lord.
Are we clear?
Yes, my lord. 2 counter affidavit.
So rejoinder to which?
Both.
Both.
How much time?
2 weeks time.
Item 46.
Please, my lord. Here I am appearing for the opposite party, the petitioner.
45 ko na?
It's adjourned along with item 16.
Oh.
My lord, pursuant to the order passed by my lord that he was continuing in his service, and now they have also stopped the salary, not yet paid, and not allowing him to continue in his service. What happened that the honorable single judge also set aside the termination order. They are making an allegation that I have filed a forged BD certificate, got an appointment in the year 2005 as a Sikhathwai, but after my lord that's after 25 years, sorry, that is after 15 years, in the year 2020, basing on one PIL, where I was not a party, there was nothing. But they have taken making an allegation that I have filed a forged BD certificate. And
what?
Forged BD certificate
BEd.
to get an appointment. That they have made registered a police case. Police also make an inquiry that from the registered Chaudhary Charan Singh University, and the registered Chaudhary Charan Singh University confirm the certificate issued by them is a genuine one. Then the police case has been dropped. Basing on that, the Honorable Singh also set aside the order passed by the block education officer, and thereafter also they preferred the writ appeal, and my lord also pleased to direct that to allow me to join, and also the salary to be released. And they have not make the inquiry, though there was an expiry inquiry. My lord also directed to make an inquiry, but no inquiry has been done. So far, they are making the allegation of the false certificate, whereas they registered the police case, found that police no the certificate issued by the university registered confirmed that this is a genuine one. After 20 years, they said, "Nah, this is a forged certificate." They have accepted the same certificate, prepared all the documents in the same certificate. Everything is okay. Now only my lord, the powerful exercise of power again they have passed the same order.
So now you'll have to reply to your submissions.
Sir.
Now the appellant will have to reply to your submissions.
Sir,
No?
sir.
Huh?
Sir.
So who has the right to begin?
Sorry, sir.
Let him speak at least 2-3 sentences. This appeal is, in fact, our memory is not so strong that we remember everything. All right. So he has.
Sorry, sir.
All right.
Thank you.
May I draw my lord's notice, my lord's order dated 26/2/2024. 26/2/2024, my order number 7, my lord.
Yes.
In compliance to my lord's direction, he was reinstated in service. Thereafter, he was given an opportunity, and it was found that the certificate submitted by him is a fraud document, and his appointment order was cancelled. Your lordship, if your lordship will permit him, I can file an affidavit to that effect that I have that order is passed. This is the order dated 7/5/2024. I can file an affidavit. annexing that document. Here will a dispute regarding the BD certificate.
Yes, now you will have to challenge it.
Yes.
Now they have taken a decision.
Same decision, my lord, same decision.
You will have to challenge it. What was the decision of the learned single judge?
That Lawrence Single Judge also set aside the order passed by the block education officer terminating my service, basing on that allegation that I have.
Sir, counsel, your matter must have been remanded back for them to reconsider. No.
No opportunity was given. That was the
The expiry order has been passed only because they are offered. Yes.
So now the order has been passed. You can challenge that.
If your lordship permits me, I can file that by open affidavit annexing that.
Mr. Panda,
Sir,
you are saying that the certificate issued by that Chaudhary Charan Singh University is
genuine.
genuine.
Yes.
But when you had entered service,
Yes.
you had given a certificate of Utkal University.
See, both also. They have accepted both.
So you have done two B.Ed. Two B.Ed courses, one under Utkal University, one under Chaudhary Charan University.
But they have accepted the BD certificate of Chaudhary Charan Singh University. The committee also accepted, and basing on that certificate, I have given appointment.
No, that you can challenge that. Where is the writ court's order?
Well, page 85.
Annexion?
Annexure 4. It starts from page 85. You lordship can find it from page 89. Last portion.
His order starts at 87.
87. First title at 85.
Yes.
Due opportunity of
So
hearing.
the everything. So now the no purpose of keeping the appeal pending. All right. And we are not interfering with the order at the same time.
Your lordship may pass that we have passed that order in compliance to my lord's order,
Yes,
and as well as
That order to comply.
And we are not interfering. That is correct order. That he had a grievance despite. No,
That has been done.
that has reinstatement.
That has been done.
Reinstatement.
one matter, your lordship may remember that matter, that for certificate in the schools, that the teachers are continuing with that for that one PI leader, that is also before my lords that.
No. After this order, he has been reinstated. And thereafter.
After my lord's order, that is my lord's order dated 26/2/2024.
Okay.
He was reinstated in service.
All right.
Thereafter, after giving opportunity,
That was because
The order earlier ordered passed by the Honorable Single Judge also.
Yes.
This intra-court appeal is against an order dated 15/2/2023 passed by a learned single judge of this court in WPC number 8931 of 2020, whereby a writ petition filed by the respondent was allowed. Has been allowed. Stop. The respondent has questioned an order of termination issued by the appellate on 28/2/2020, whereby his service was terminated, whereby his services were terminated with immediate effect on the ground of submission of fake certificate at the time of his appointment. The top and single judge, after having noticed the statutory provisions and law in this regard allowed the writ application in following terms. Paragraph 9. Oh, stop. Next, it is not in dispute that the said termination order was passed without giving the petitioner an opportunity of hearing. Oh, stop. In that background, when the present appeal was taken up for hearing, was taken up on
2024.
On 26/2/2024, following order was passed. We have been where is that?
The learned single judge was of the view that the respondent was not, no. Instead of giving the respondent an opportunity of hearing, the state has chosen to prefer this intra-court appeal on the ground that the respondent was given due opportunity of hearing. And since his due degree was expired, vacant post.
Whether any opportunity of hearing was given?
Yes, you'll also see that order, my lord.
No, not this. You had challenged, you had filed this appeal stating he had been given opportunity of hearing. Is that
we have-
correct or that's a ground?
We have given that opportunity. He says that opportunity he has not appeared before that inquiry.
No. When he was on leave, he was on medical leave, he has passed the order.
Okay, that means you gave an opportunity, but he has not availed.
Yes.
All right.
So Honorable Single Judge has said that no opportunity, that I am not disputing that because we at present we have given that opportunity, he cannot deny it.
We have been informed by Mr. Kutyal AG that pursuant to this court's order dated 26/2/2023.
24.
Para 7 of the order passed by the Honorable Single Judge.
After giving the petitioner an opportunity of file his so cause and hearing, opportunity of hearing, an order has been passed on 25/2024. A copy of the said order has been placed before us. You have received?
Yes.
Which learned counsel which the respondent is said to have received. Full stop. Next, we do not find any legal infirmity in the impugned order passed by the learned single judge. Stop. Now, since the order passed by the learned single judge, pursuant to a subsequent order passed by this bench on 26/2/2023-24, an order has been passed on 7/5/2024. 7/5/2002 by the block education officer, Morai, this intra-court appeal stands disposed of with a liberty to the respondent to question the correctness of the order set dated 7/5/2024 before appropriate forum in accordance with law.
Item 47.
May I please your lordship, I'm appearing on behalf of Mr. D. N. Rath, lordship, I pray for an adjournment due to certain personal difficulty, he wasn't able to appear today.
When do you want?
Lordship, 2 weeks after.
Personal difficulty is for 2 weeks.
Lordship, any date,
All
on.
it is requested on behalf of the appellant list this matter on 2 weeks. Any? Yes.
Item number 48.
Grateful, lordship.
A classic case of direct confrontation with the judgment passed by this honorable. In other words, on 25/1/2025, lordship sees that judgment passed by this honorable court, that is page
PIL.
49.
This is PIL.
But it's a writ of quo warranto. Page 49, your lordship would just see.
It's in nature of PIL, my lords.
It's a PIL.
In nature of PIL.
Oh, co-warrant is not required to PIL. Yes.
Kindly see page 49. Warrant is nature of a PIL. 25/1/2023,
Just a minute. Which page?
page 49, running page 49.
Annexure 10, page 2.
Right. That's the page starts from Annexure 10, page 48.
Yes.
The date of judgment is 25/1/2023. This very opinion 9's reappointment as managing director of the bank was challenged on several questions of law. This honorable court, after hearing everyone, by the detailed judgment on 25/1/2023 precisely on 3 grounds, that there is violation of GA Department Circular, there is violation of Cooperative Society Act, there is violation of Banking Regulation Act, which is Central Act. What's the appointment of OP number 9? If lordship would kindly see that ordering person, the writ of warrant was issued removing
OP number 9?
But the OP number 9 here in this writ petition, there also was the.
Who is OP number 9? Which post is it?
But it is managing director of Odisha State Cooperative Bank. That very OP number 9.
When was he appointed?
He was appointed in that very bank itself. He was continuing in that bank.
When was he appointed as MD?
But his appointment as MD in this bank.
That you must have challenged.
No. That original appointment was never challenged. He was continuing there. After his retirement, he was reappointed in the same bank.
All right. So when?
That date. That is no. That is not Annexure 1. That is, I am giving the date, my lord. Lord,
25/1.
That is 2nd of March 2022. Re-engagement.
Last paragraph, it is there, page 65. Notification dated 2nd March.
March 2022.
OP 7.
Right.
It was
He was appointed as?
Reappointed as the managing director of that very bank after his retirement.
So how is this appointment bad?
Milord, yes. This has been dealt with in this judgment. It was bad on the ground that there was a GA Department circular which says that a retired employee can be reappointed only by following a process of advertisement and transparency. That is 1. 2. A retired employee, there is no stopgap arrangement in this bank because the law provides that there shall be a full-time managing director. Odisha Cooperative Society Act provides. 3. The Banking Regulation Act provides that prior to appointment of managing director, a prior approval from Reserve Bank of India is mandatory. But all these three.
I mean, without going into it, two questions arise. One is, if a person has already been appointed and it is a continuation, will that sanction be necessary?
Yes, it is.
That is one.
No,
All
it's necessary because that is what has been already held by this honorable court in this judgment. If your lordship sees that judgment, that is, I was trying to show your lordship, Lord, page 49. Precisely on these three grounds, he was removed.
Page
But the day the judgment was passed and he was removed, the same day again he has been reappointed. That is the point. That is how this honorable court at the stage of admission was pleased to again stay it. The day he was removed by a judgment passed by this honorable court, which has attained finality, has never been challenged by anyone. On the same day again he has been reappointed. That is why I say it's a classic case of confrontation with this honorable court.
No, there is no conflict.
That appointment was for 1 year.
Which one?
The earlier appointment which you had challenged.
He was removed. He was removed. Kindly see page 64.
No, that appointment was set aside, but that was for 1 year.
That was set aside.
So after that expired, they appointed.
The day the judgment was delivered, same day again. Again, without taking prior approval from RBI, without following due process of law, without making an advertisement.
So where is the provision that requires approval?
Right. That is Banking Regulation Act. Section 35B of Banking Regulation Act. Kindly see Banking Regulation. I'm so sorry, Lord. My
extra
yes, it is. 35B. I'm sorry.
My lords, if I have your permission, I appear for the bank. I don't want to interrupt his submissions, but as far as the opposite party number 9 is concerned, here's a point. Yes.
We are reading the order.
I'm sorry.
Reading the judgment or
Judgment.
Judgment. Correct.
Yes, where is the act?
Yes, Lord. Banking Regulation Act.
No, OCS Act.
Achha, OCS Act. Right. 23. Let's see, page, section 28, 3B1. If I can locate that.
Just. So the order which is under challenge in the present case, whether before his appointment or reappointment, right? Previous approval was Reserve Bank was
never
obtained or not?
No. That's the admitted position. RBI has filed counter. That's the admitted position. If your lordship is holding the same book, page 52, man. Your Lordship, you are holding this.
Section? Section.
Section 28 3B1.
No.
Notwithstanding anything contained in this act.
Right. I'm so grateful. So grateful.
Where is 3 capital B1?
Let's see, he's asking about 33B1.
Please come to paragraph 30 of this court's judgment.
Right.
Oh,
That is the banking regulation.
All right. Sorry.
That is Banking Regulation Act.
Oh.
That is with the prior approval of RBI.
The approval of the registrar is also not there.
Not there.
Even in the reappointment.
Beg pardon, madam.
Even in the reappointment, there is no approval.
But here, yes, there is an approval.
Now there is an approval.
Now the approval is there.
So therefore, there is compliance of 3B. 28 3B1.
28 3B1, Lordship will kindly mark. There is a reference about a whole time managing director. So you cannot appoint a temporary managing director for part-time.
No, by whole time, what do you mean? Part-time, whole time means must
Yes,
be holding
means
two posts.
a regular managing director being appointed through following the provisions of law.
How do you say that he is not a whole time?
That the order itself fixed.
What?
That kindly see the impugned order.
Is there in the...
That is there. That says that he is appointed till the post is filled up in due course.
No, that is not part-time. Part-time means he is doing something, and in addition to that, he is being appointed. So whole time is for that period only.
But subject to appreciation, here is a person who this person is a retired person.
Yes.
Now he was reappointed, and his reappointment was set aside by this honorable court by a judgment on the ground of violation of law.
Yes.
Now the day judgment was passed, on the same day the reappointment order has been passed again.
That can be done.
Yes, but subject to the compliance of law again.
Yes.
The 35B1 has not been complied with.
35, yeah, we will see. We'll see.
That is one. Two, if your lordship sees this reappointment here, again violates the mandates of law. The reason being, the GA department circular, it is clearly there. In case of reappointment of a retired person, there has to be a principle of transparency about appointment, advertisement, and process of selection. That is there. Kindly see 2014 circular. That has again not been given a go by completely.
What is the GA department covers the appointment?
Yes.
Of the bank?
Yes.
How?
That is they follow it, man.
That circular is not.
And one more circular is also there.
Circular is not law. This is what has been held by.
But I'm submitting one more thing. There is also a guideline issued by Corporation Department that a retired employee cannot be reappointed. That is also there. I can show that.
Come to paragraph 32.
32 of this
of this court.
32. The court clarifies that above conclusion doesn't in any way, manner reflect on the capability or integrity. That is there.
Please read it.
Yes, sir. Integrity of OP number 7 or his qualification to hold the post of MD.
So qualification, the court says that he is not qualified.
Also not that.
You are saying this.
No, I am not.
That he is retired employee, therefore whole time.
I am not.
Yes, please come.
But I am not questioning the qualification at all.
All right.
But I am only questioning the violation of law. That's all.
Then again come. It is also clarified.
Since that is not an issue in the present writ petition, that was never the issue there. Here also that's not the issue. It is also clarified by this court that since what is under challenge in the present petition seeks a writ of quoranto, is the legality of order of re-engagement OP number 7 as MD OP number 8 bank. This judgment would not ipso facto result in invalidating any other appointment made by the government of any person or any other post in a public body. They are all for other departments, not for this.
The court did not restrain that he should not be appointed.
Here they said that in case of nullifying this.
Who is for the other side?
My lords, I appear for the bank. Now, I had sought to make a submission that as far as
Who is the competent authority to appoint?
now, as far as this judgment is
Who
concerned,
is the competent authority to appoint?
the competent authority is the managing committee of the society, which is the cooperative bank. Now,
Yes.
before they do that, my lords, according to the Act, they have to take prior approval of the Reserve Bank of India.
Yes,
So that was not done in this case.
yes.
Now, my lords, his first appointment was quashed by the order of this court. We made a subsequent appointment, which my lords has seen is only for a temporary period, because now we've initiated the process to appoint a full-time managing
When
director.
did you appoint him?
On the 21st of January, 2023. This is after the judgment.
All right. So that was a temporary arrangement.
That was a stopgap arrangement. Now, on the 16th of February, my lords, this court passed an order removing him from office, an interim order, removing him from office and asking him to hand over immediate charge to the registrar. That was so done on the 16th of February. Now, my lords, since quite a bit of time has passed, that gentleman, which is opposite party number 9, is now no longer in contention. That's the short submission I wanted to make. So there would be no possibility of his being appointed as managing director of the bank. So I just wanted to make the short submission that nothing remains in this case.
So someone is appearing for him.
I believe he was represented by counsel on the previous dates. I don't know if today they're
Who appears? So it has become infructuous.
It's infructuous, my lord. It's academic now.
That this reappointment doesn't hold good anymore. If such a statement is made,
My lords may record my statement.
or they do not intend to continue with this person.
Yes.
If that is the statement,
They're saying
I've been removed. There's no question of his continuance, my lords.
that interim order be made final. This may be disposed of.
No, we will know. If he is saying, therefore we wanted
Yes,
the presence
my
of.
lord.
Suppose you are challenging appointment of respondent number 9.
Correct, my lord.
And respondent number 9 doesn't want to continue.
That then I will definitely not have any cause of
So
action.
therefore, we want who was appearing?
They are not probably appearing here in this matter. Previously, they were appearing. In this matter, notice, I had taken out notice.
Because if I may, my lords, the bank right now is in the process of appointing a new managing director.
All right. So should we record your?
Absolutely, my lords. Yeah.
The present writ application seeking issuance of a writ in the nature of a writ of quo warranto. The petitioner has questioned legality of appointment of respondent number 9 as the managing director Orissa State Cooperative Bank, Bhubaneswar bracketed Khurda. Stop. We are not required to go into unnecessary, the factual aspects which have become irrelevant because of the subsequent development and the stand which has been taken on behalf of Odisha Cooperative Bank. All right. Stop. Suffice it to say that this court, by say that an interim order was passed by this court on 13/9/2023 to the following effect.
Lord, the original order is dated 16th of February 20.
No, 16th of February.
Correct. Wherein it was stated you were directed to hand over charges.
16th of February.
Correct.
Just 16th of February. Court. 16th of February. That's pursuant to the said interim order of this court. It has been stated by Mr.
Sunil Matthews.
So,
It's in the cause list.
representing Odisha State Cooperative that in the light of the interim order dated 16/2/2023, the respondent number 9 was removed from the office of the managing director of the bank. Also, he has submitted that there is no question of respondent number 9 being appointed now as managing director of the bank, as the bank is contemplating to take.
It's initiated the process, my lords.
The bank has initiated process of there is no question of respondent number 9 being continued as the managing director of so and so bank on the strength of the appointment order dated
25th of January 2023.
25/1/2023, which is under challenge in the present writ application. Since steps have been taken for selection of a managing director of the bank in accordance with law. Stop. Next, in such view of the matter, this writ application is disposed of as having become infructuous.
That's it. Obliged, my lords.
Item number 49.
May I please, your lordship? I've received the copy of the report of the RDC, my lord. I've gone through it. It's clearly, it can be seen that it's the illegal, my lord. Illegally, they have constructed such vending zone, my lord.
The original report is with me. May I submit it?
Lord, I have not, last occasion, day before yesterday, when it was listed before your lordship.
I'm just now serving it. The original is with me.
My lord, let them serve me a copy. Let me also go through it, because your lordship had directed service of that report to both the parties. I am for the municipality, whose construction is under challenge before your lordship in this writ application. So at least I will just go
It is
through
with
it.
me, just I was searching.
I can assist your lordship in.
RDC report. That is original.
Original report
That
of
is original report. I was searching for him. Just now I will give a copy to Mr. Bose.
Which is the last order?
Day before yesterday, on 18/6/24, your lordship had.
What is the result? What is the report? Conclude.
The field position has been reported by the RTC.
in the light, in the light of this court's order dated 19/3/2024, a report has been filed, prepared by the report of the Divisional Commissioner.
RDC ND, Northern Division.
Revenue
Divisional Commissioner.
Divisional Commissioner, Northern Division.
Northern Division has been filed today.
The original copy is.
The report has been filed today, which is taken on the court. Let a copy of the said report.
I have received the.
You are for?
My lord, I am for the municipality. Opposite party number 3 and 4.
The petitioner has received a copy.
We served upon land council representing the municipal corporation.
Yeah, my lord, it is municipality. It's not corporation.
Which municipality?
It is Devgarh municipality.
Devgarh municipality. In course of the day. You can do that?
Within half an hour answer.
Course of the day. List this matter on. Monday we can take up.
My lord, may grant me a 10 days time. I will also ascertain from the municipality also.
2 weeks. In this case on 2 weeks. Now, what is the report, Mr.?
It is illegal, my lord. The construction is done is illegal, violating the municipality rules, my lord.
Examine that.
Yes.
Examine and act. If it is illegal, then.
My lord, RDC has given, I have nothing to say. Just I will apprise my position from the client.
May my lord. It is clearly written that under the hanging structures, the vendors are supposed to.
Yes. Apprise and take follow back.
Madam.
Inform this court. Why should see these?
If the RDC has given the report, then
If you do it
municipality has no other option. Municipality has no other option. They have to comply the
My
order.
lord, I have to take. I have
Yes,
to
yes,
ask my
yes.
client.
See, this report of the commissioner is not his report as the
Yes, ma'am. I am not on
revenue
that.
commissioner.
I am not on that, madam.
It is a report of an officer of the court. Apart from the position which he holds.
My lord, I am not disputing that. Just I will take instruction from my client so that I can assist your lordship more properly.
Clearly it is stated that, my lord, that the state provisions are violated.
We will raise any urgent matter? Can we?
Lordship, item number.
Lordship has been posted on 17th of next month.
59.
That it can be tagged up.
The interim order may kindly be extended and it may kindly be tagged with WPC number 3181 of 2022, which is the lead matter.
It has been fixed on 18th July, 2 p.m.
No, but
My lord.
that is expiring.
Whether it is the next date.
All the matters shall be listed on Monday, madam.
Lordship.
My lord,
My only prayer is to extend the interim order, Lordship. My only prayer is to extend the interim order and it may be tagged with WPC number 3181 of 2022, which is the lead matter in this case.
3181. What is that? See, what is the lead matter? What is this matter about?
3181 of 2022. It is GST on royalty, Lordship.
All right. 3181 of 20.
my lord, it has been 59.
Along with.
Similar matters are.
Yes, my lord, it has been
Yes,
fixed
it is
on
pending.
18th July 24, 2 p.m. Specific direction.
This is another order. Another petition. Which item?
No, this matter only. I am for the opposite party.
All right.
59.
It has been.
So that will be, this case will also be listed along with that.
It is on 18th July, 2 p.m.
Okay.